Quorum is present and the committee meets today pursuant to notice to consider HR 3110, providing urgent maternal protections for Nursing Mothers Act, and HR 2062, protecting older workers against discrimination Act. Chair announces that any request for recorded votes may be rolled pursuant to clause 2 of Rule 11 of the House Rules and Committee Rule 14B. Pursuant to House Rule 11, Clause 1, the chair may recess the committee at any point. While a roll call is not necessary to establish a quorum in official proceedings conducted remotely or with remote participation, the committee has made a practice whenever there is official proceeding with remote participation for the clerk to call the roll to help make clear who is present at the start of the proceeding. Members should say their name before announcing they are present. This helps the clerk and also helps those watching the platform and live stream who may be experiencing a few seconds delay. This time, I'll ask the clerk to call the roll.
Chairman Scott.
Chairman Scott is present.
Mr. Grijalva.
Certain economic conditions. Thankfully,
Mr. Courtney.
Courtney is present.
have for the most part,
Mr. Sablon.
as we will hear from our panel of expert witnesses today,
Ms. Wilson.
during COVID has been crucial for those suddenly without an income.
Ms. Bonamici.
Suzanne Bonamici is present.
Mr. Takano. Ms. Adams.
Present.
Mr. DeSaulnier.
DeSaulnier, present.
Mr. Norcross.
Don Norcross, present.
Ms. Jayapal.
Jayapal is present.
Mr. Morelli. Ms. Wild. Mrs. McBath.
McBath, present.
Mrs. Hayes. Mr. Levin.
Levin is present.
Ms. Omar. Ms. Stevens. Ms. Ledger Fernandez. Mr. Jones. Ms. Manning. Mr. Mervan.
Mervan is present.
Mr. Bowman.
Mr. Bowman is present.
Mr. Pocan.
Can is present.
Mr. Castro. Ms. Sherrill. Mr. Yarmouth.
Yarmouth is present.
Mr. Espaillat.
Espaillat is present.
Mr. Umfume. Ranking Member Fox. Mr. Wilson.
Bill Wilson is present.
Mr. Thompson. Mr. Wahlberg.
Wahlberg is present.
Mr. Grossman. Ms. Stefanik. Mr. Allen. Mr. Banks. Mr. Comer. Mr. Fulcher. Mr. Keller. Mr. Murphy. Mrs. Miller Meeks. Mr. Owens. Mr. Good.
Good is here.
Mrs. McLean.
McLean is present.
Mrs. Harshbarger.
Harshbarger's present.
Mrs. Miller.
Mary Miller's present.
Mrs. Sparts.
Sparts is present.
Mr. Fitzgerald. Mr. Cawthorn, Mrs. Steele,
Steele present.
Ms. Letlow.
Letlow present.
Chairman Scott, that concludes the roll call.
Jones today, but it has not been the bulk.
Could you repeat who just spoke up? I'm sorry. Did someone seek recognition?
Yes, Mr. Chairman, Jones is present.
Mr. Jones is present. Anyone else? Thank you. This is a remote markup pursuant to House Resolution 8 and the regulations thereto. All microphones shall be kept muted to avoid unnecessary background noise. Members are responsible for unmuting themselves when they're recognized to speak or when they wish to seek recognition. I also ask that members please identify themselves before they speak. Members shall be considered present in the proceeding when they are visible on camera, and they shall be considered as not present when they are not visible on camera. The only exception to this is if they are experiencing technical difficulty and inform the committee staff of such difficulty. However, members must be visible on camera to count toward a quorum and to vote. And the rules provide no exception to this. Moreover, there needs to be a verbal vote when we're voting so that both the clerk and the official reporter stenographer can hear it. A thumbs up or a thumbs down without a verbal vote will not suffice. If any member experiences technical difficulties during the hearing, you should stay connected to the platform, make sure that you're muted, and use your telephone to immediately call the committee's IT director, whose number was provided in advance. Should the chair experience technical difficulty or need to step away, Mr. Levin, Mr. Courtney, or any other or another majority member of the committee, if they're available, if Mr. Levin and Mr. Courtney are not available, is hereby authorized to assume the gavel in the chair's absence. This is an entirely remote markup, and as such, the committee's hearing room is officially closed. Members who choose to sit in the committee room with their individual devices must wear headphones to avoid feedback, echoes, and distortion resulting from more than one person on the software platform sitting in the same room. Members are also expected to adhere to social distancing and safe healthcare guidelines, including the use of masks and sanitizer, and cleaning the areas both before and after their presence in the hearing room. Amendments must be submitted electronically to the amendment repository pursuant to the instructions in the notice of amendment process that was distributed to all committee officers by the clerk with the markup notice. Amendments must be submitted to the repository before they are offered at the markup. In order to ensure that the committee's 5-minute rule is adhered to, staff will be keeping track of time using the committee's field timer. The field timer will appear in its own thumbnail picture and will be named 001_timer. There will be no 1 minute remaining warning. The field timer will show a blinking light when the time is up. Members are asked to wrap up promptly when their time has expired. I'll now recognize myself to make an opening statement. And I understand we began without the ranking member present. I was advised that she would be here presently and to proceed without her. Has the ranking member appeared yet? Well, if she is not here when it's her turn to make an opening statement, we'll reserve that time for her. Today, the committee is marking up 2 bipartisan bills that will help secure basic protections for our nation's workers. These bills are H.R. 3110, the Providing Urgent Maternal Protections for Nursing Mothers Act, or PUMP Act, and H.R. 2062, the Protecting Older Workers Against Discrimination Act, or POWADA. The first bill, the PUMP for Nursing Mothers Act, extends critical workplace protections that guarantee nursing workers the time and privacy they need to express breast milk. More than 10 years ago, Congress passed legislation that required employers to provide eligible nursing workers with a clean, private space and time to pump but does not need to be paid time. Unfortunately, gaps in the law exclude millions of workers and also limit how protected workers can recover for harms in court when their rights are violated. In a national survey of women who gave birth in 2011 and 2012, more than 1 in 3 reported that employment posed a challenge to breastfeeding. For nursing mothers, access to these protections has always been critical for balancing work and health of both themselves and their infants, but it's particularly essential now as women return to work after disproportionately suffering from employment losses during the pandemic. The bipartisan, bicameral Pump for Nursing Mothers Act would expand access to existing protections for nursing mothers to nearly 9 million employees who are currently left out. It would also ensure that nursing workers have access to appropriate remedies when their employers fail to provide break time and appropriate pumping space. Finally, the bill would clarify that if an employer is not completely relieved of their duties during a break, that time is considered hours worked for the purpose of minimum wage and overtime requirements. This legislation is a simple improvement to existing law. It would strengthen our economy and meaningfully support nursing mothers across the economy. I'm pleased to report that after extensive discussions, the final proposal that will be introduced as an amendment in nature of a substitute is supported by worker advocates, civil rights and public health groups, and the United States Chamber of Commerce. The second bill that we'll consider is the Protecting Older Workers Against Discrimination Act, which would provide older workers with urgently needed protections against age-based workplace discrimination. In 1967, Congress recognized the need to protect older workers, specifically those over 40 years of age, from discrimination by enacting the Age Discrimination and Employment Act. Unfortunately, in 2009, the Supreme Court severely eroded these critical protections in the case of Gross v. FBL Financial Services. In its decision, the court imposed a higher evidentiary standard that courts had previously required. Now workers must prove that age discrimination was the decisive motivating cause of the employer's action rather than one of the motivating factors. This standard is a needless barrier to workplace fairness for older workers who have long been vulnerable to workplace discrimination. In fact, more than half of older workers are pushed out of long-time jobs before they choose to retire. Age discrimination also holds back our economy. Research by the AARP and the Economist Intelligence Unit found that absent age discrimination, older workers would have contributed $850 billion more in 2018 to the gross domestic product. It is clear that our labor market and economy cannot fully recover as we fail to include and protect our nation's older workers. The Protecting Older Workers Against Discrimination Act is a bipartisan legislative fix that would restore the pre-2009 evidentiary standard for age discrimination claims. This would effectively realign the burden of proof for age discrimination claims with the same standards for proving discrimination based on sex, race, religion, and national origin. The legislation also reinstates the standard for disability discrimination claims and those involving retaliation for rights protected under those civil rights laws, which have been implicated by the Supreme Court's holding in Gross. In 2019, 227 House Democrats and 34 House Republicans came together to pass this bill. This Congress, we must reaffirm our bipartisan support for older workers by again passing the Protect Older Workers Against Discrimination Act. As our economy continues to recover from the pandemic, both the Pump for Nursing Mothers Act and the Protecting Older Workers Against Discrimination Act would help ensure that nursing workers and older workers can work free from fear of discrimination. If the ranking member is with us.
Yes, sir, I'm here.
Oh, okay. I'll yield now to the distinguished ranking member for her statement.
Thank you very much. Thank you for yielding, Mr. Chairman. As I've said before, it's disappointing and unnecessary we're having yet another remote markup especially in light of the new CDC guidance. As members of Congress, we can and should be showing the American people that safely returning to doing our jobs in person is possible by holding this markup in our committee room in Washington, D.C., where I am today. Speaking of leading the way, the bills before us today are also less than exemplary. While I believe they address important issues, they fall short in practice. The American people deserve better. Let me be clear. Committee Republicans believe that discrimination in any form is wrong. It is illegal in the United States and has been for decades, as it should be. Older Americans and nursing mothers can face unique challenges in the workplace, but there are already laws in effect preventing employers from discriminating against these workers. These bills are counterproductive. We'll start with the Pump for Nursing Mothers Act. Committee Republicans believe nursing mothers deserve adequate protections in the workplace. The Fair Labor Standards Act already requires employers to accommodate working mothers in hourly jobs who need time and a private space to pump breast milk while at work. Additionally, now more than ever, we need to advocate for flexible workplace policies that improve conditions for and empower working mothers. Unfortunately, this bill is not a step in that direction. It takes a sweeping and more punitive route, creating extra hurdles and penalties for employers that are both unworkable and unnecessary. This is no way to empower women or facilitate their participation in the workforce. HR 3110 takes a one-size-fits-all approach, treating all nursing mothers in workplaces as if they are all the same. Certainly, nursing mothers working remotely or in unique workplace environments, such as transportation and farm operations, have different needs than those working in an office or a warehouse. Failing to account for these differences will not help women in the least. It will make it more difficult for employers to create a work environment that meets the needs of working mothers. The excessive penalties on employers for non-compliance mandated by the bill, coupled with its sweeping coverage, will encourage frivolous lawsuits by trial lawyers instead of improving working conditions for mothers. Yet again, Democrats have conveniently marketed their trial lawyer payoff as a win for nursing mothers. The Protecting Older Workers Against Discrimination Act also falls short. This proposed bill from committee Democrats purports to help older workers. What it really does is further the Democrat pro-trial lawyer agenda under the guise of protection. HR 2062 goes far beyond age discrimination cases and impacts disability and retaliation cases. Congress purposefully enacted separate non-discrimination statutes, including one specifically pertaining to age discrimination. Multiple Supreme Court decisions have affirmed that age discrimination involves unique and complex factors. But HR 2062 overturns this. The bill changes the law to allow employees to claim that age was not the decisive cause of the employer's decision, making it much easier for an employee to get past the summary judgment stage of litigation, even if the claim is dubious. However, this change in the law will not benefit older workers. Democrats argue that making it easier to sue for discrimination will benefit older American workers. But under HR 2062, a successful plaintiff will most likely receive no monetary award or other relief from the defendant, while the plaintiff's attorney will be awarded fees, and the plaintiff could owe income tax on those fees. The bill gives trial lawyers endless paydays at the expense of the hardworking people it purports to help. Additionally, An increase in lawsuits will reduce or redirect important resources that could otherwise be used to combat workplace discrimination. As such, this bill will not help the workers it purports to benefit. HR 2062 is misguided and it lacks thoughtful deliberation for older workers and the other workers affected by the bill. Democrats have not shown any data or evidence that the changes in the bill are even necessary. It's no wonder that they rushed it through the committee without thorough review. Mr. Chairman, the legislation before us today represents big wins for Democrat special interests, namely trial lawyers, not working class America. Our country is the land of opportunity because everyone from all ages and walks of life has the chance to participate and prosper. These bills, rather than successfully address real world problems, will only enrich the Democrats' political allies. I strongly urge a no vote on these bills, and I yield back.
Thank you. Without objection, all other members who wish to insert written opening statements into the record may do so by submitting them to the committee clerk electronically by the end of the day today. House rules require that a copy of the measures be made available to members and the public at least 24 hours in advance, and this was done. The committee will now proceed with the consideration of the bill HR 3110 for amendment. The bill was circulated in advance, and the clerk will designate the bill.
HR 3110 to amend the Fair Labor Standards Act of 1938 to expand access to breastfeeding accommodations in the workplace and for other purposes.
Without objection, the first reading of the bill is dispensed with. And without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. I now recognize the gentlewoman from North Carolina, Ms. Adams, to offer an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will designate the amendment.
Amendment in the nature of a substitute to HR 3110 offered by Ms. Adams. The identifier is Pump Act _ANS.
Without objection, the amendment shall be considered original text and open.
And I can be cheerful mostly, but.
Just a minute. Without objection, the amendment shall be considered original text and open to amendment at any point. The amendment in the nature of a substitute was distributed electronically in advance. I now recognize the gentlewoman from North Carolina for 5 minutes to explain the amendment in the nature of a substitute.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. As an original sponsor of the providing urgent maternal protections for nursing mothers, or the PUMP Act, I'm pleased to support this bipartisan amendment in the nature of a substitute. This bill reflects a bipartisan compromise. It's supported by a broad range of stakeholders, including worker advocates, public health organizations, and the U.S. Chamber of Commerce, the world's largest business organization representing companies and employers of all sizes across every sector of the economy. A lot of hard work went into securing this bipartisan deal, and I'm proud of the efforts that we've made to ensure that all relevant stakeholders were included. This amendment improves on how HR 3110, the PUMP Act, by changing the current undue hardship exemption to apply to employers with fewer than 25 employers, rather than employers with fewer than 50 employees under the current law. This expansion could guarantee millions more workers and working mothers the right to break time and a clean space for expressing milk to feed their infants, toddlers, and young children. Additionally, it will require the Department of Labor to issue guidance with examples of how to comply in line with the existing guidelines provided on the Department of Health and Human Services Office of Women's Health website on supporting lactating workers. This guidance will help employers who will be newly covered under the law and will give them the tools to come into compliance as they provide this break time and clean space for their employees. It also includes a reasonable requirement for employees to inform their employers about inadequate space no less than 10 days before filing suit if the employee's reasonable request is not remedied or addressed. It also adds language to ensure that meeting the requirements of this law does not mean an employer is off the hook for complying with other federal laws that provide greater protection. We that these provisions, along with the updated remedies in HR 3110, will create a meaningful impetus for employers to comply with the law and provide necessary break time and space to lactating workers. Millions of nursing moms are in the workforce. They need protections to pump breast milk. These moms also are breadwinners for their families. More than half of mothers return to the paid labor force before their children are 3 months old, with as many as 1 in 4 returning within 2 weeks after giving birth. Many of these mothers choose to continue breastfeeding well after their return to work to meet the standard health guidelines, and those employees need to express or pump breast milk on a regular scale. The time break for nursing mothers law passed in 2010 provided critical protections to ensure that employees would have reasonable break time and a private place to pump. But because of an unintentional gap in the law, millions of nursing mothers were left without a clear right to pump. So with these protections, nursing mothers face serious health consequences, including risk of painful illness and infection, diminished milk supply, or inability to continue breastfeeding. According to a recent report from the University of California Center for Work Life, the consequences of this coverage gap also include harassment, reduced wages, and job loss. So if you support working mothers, you should support the PUMP Act. And thank you, Mr. Chairman, and I yield back.
Thank you. Does anyone seek recognition?
Yes, Mr. Chairman, I have.
Distinguished ranking member is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, committee Republicans are strong advocates of flexible workplace policies that improve conditions for and empower working mothers. Unfortunately, HR 3110 takes an unnecessary, punitive, and sweeping approach, creating excessive burdens and penalties for certain employers that are both unworkable and unreasonable. The Democrat amendment.
I'm sorry, Dr. Fox.
That's okay.
Continue.
The Democrat amendment in the nature of a substitute offered at today's markup fails to address some of the critical flaws in the underlying bill. First, it continues to impose the bill's requirements on those businesses that are least able to apply. Under existing law, employers with fewer than 50 employees are not subject to the FLSA accommodation requirement if compliance would impose an undue hardship by causing significant difficulty or expense when considering the size, financial resources, nature, or structure of the employer's business. The ANS cuts that threshold by half to 25 employees, exposing more establishments to the flawed requirements of the underlying bill. Secondly, the Democrat ANS maintains the language in the underlying bill, which markedly expands FLSA remedies for violations. These disproportionate penalties are an inappropriate response to possible compliance violations related to FLSA's workplace nursing mother accommodations. The Democrat ANS includes an alternative dispute mechanism, which allows employers an abbreviated time frame of 10 days to address an accommodation request before penalties apply. Unfortunately, falling short of what is appropriate to ensure employers are able to provide accommodation to employees. The Democrat ANS continues to impose a one-size-fits-all mandate on diverse businesses, including those that operate in remote environments or lack the necessary physical infrastructure to meet the bill's requirements. It also maintains requirements that will negatively impact businesses involved in transportation and agriculture, where the nature and location of work is not conducive to the mandates included in the bill. For example, the Democrat ANS would require that airline employees who are currently exempt from these requirements have access to a space and time for pumping breast milk, despite the fact that aircraft designs are regulated by the FAA for safety and reliability purposes with limited ability to add additional spaces. Remote or rural airports would face unique challenges when accounting for small planes that operate out of these regions, including maintaining staffing levels and access to services. As recently as 2019, the FAA argued that meal and break rest laws are in conflict with flight personnel duties under FAA requirements. In light of these circumstances, air carriers are exempt from current FLSA nursing mother accommodation requirements. However, these employers accommodate nursing mothers in flight crews in other ways, including extended paid and unpaid maternity leave, temporary accommodations and office jobs on the ground, and the ability to work short regional flights with opportunity to pump milk in between flights on the ground. Additionally, the Democrat ANS maintains a questionable scheme that conflicts with current wage and hour treatment of break time compensation under FLSA. The ANS changes current law and requires that individuals be entirely relieved from work for a break to be unpaid, with an employee owed compensation for the entire break time in the event that any work is performed, failing to account for the realities of many modern workplaces. For instance, passive work time such as email, phone, or radio monitoring would trigger the bill's requirements for compensation, even when these activities occur in small increments. However, the ANS fails to account for the privacy needs of nursing mothers, creating conflicts between maintaining the private nature of time spent pumping breast milk while also requiring employers to monitor whether work is performed or not. In summary, the Democrat ANS continues to take an unnecessary, punitive, and sweeping approach. The Democrat ANS keeps the one-size-fits-all scheme in HR 3110 and treats all nursing mothers and workplaces as if they're the same, despite known differences in employees' needs, industry-specific challenges, and the ability of certain employers to meet such standards. Undoubtedly, nursing mothers working remotely or in unique environments have different needs than those working in an office or a warehouse, yet the Democrat ANS fails to account for all those differences. For that reason, I am offering an amendment in the nature of a substitute to the bill, and I yield back.
Thank you. A gentleman from New York, Mr. Bowman. Recognized for
Mr.
5
Chairman, I
minutes.
seek recognition and I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. Today's markup of the Pump for Nursing Mothers Act is incredibly important, and I commend your leadership in bringing forward a bill that strengthens protections for millions more nursing workers. What we are trying to do today is very simple. Needing to pump is as natural and necessary for nursing workers as is going to the restroom. When we hear about workers who are denied bathroom breaks, we clearly see the wrong done. With the Pump for Nursing Mothers Act, we can make sure millions more nursing parents can be on the job and provide for the health of their infant child. I particularly wish to celebrate the Pump for Nursing Mothers Act for expanding protections to include teachers. Teachers are currently excluded from workplace nursing protections. We entrust our teachers with the education and well-being of our children. We absolutely should make sure that nursing teachers can pump as needed for the well-being of their own children. Failing to do so is unacceptable. The benefits of breastfeeding are clear across the board, including lower risk of asthma. Part of my district includes the Bronx, and this issue is personal for my constituents. The Bronx has some of the highest rates of childhood asthma in the country. Making sure more nursing workers, including teachers, can pump at work could very well be the difference between eliminating childhood asthma in my community and not. I also wish to highlight the importance of remedies. Some workers have technically been protected by current law with access to a private space for pumping, but in practice do not. This can be an issue in workplaces that employ fewer women, such as construction sites where women make up less than 10% of the workforce. Many construction sites do comply with requirements by setting up a separate station on site that is not a portable bathroom. However, I've heard from constituents of instances where that hasn't always been the case. The Pump for Nursing Mothers Act makes sure nursing workers can access equitable remedies that cover the economic, health, and emotional harm caused by an employer's failure to comply with break time and space requirements. This is an important step in the right direction for all workers. Thank you, and I yield back the balance of my time.
Thank you. Do any Republican members seek recognition? I don't see any. If not, does the gentlelady from Oregon, Ms. Bonamici, seek recognition?
Yes, thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chairman. I strongly support the Pump for Nursing Mothers Act, and I thank Chairman Scott and Representative Adams. Representative Adams and I co-chaired a hearing on workplace discrimination in which we discussed the Pump Act, as well as the Protecting Older Workers Against Discrimination Act. We know, as my colleague from New York just noted, that breastfeeding provides multiple benefits for mothers and babies. As someone who had to pump in bathrooms, I know how important it is for mothers to have a safe place and clean place to pump. Now, I note that I have spoken with many small businesses that have family-friendly policies like the Pump Act, and they've told me that these policies actually help with recruitment and retention because they recognize that happy, healthy workers are good for business. I also want to note, Mr. Chairman and colleagues, that unlike most developed nations, the United States still has no universal paid family leave policy, and that makes the Pump Act even more important. I urge all of my colleagues to support the amendment in nature of a substitute, and I yield back the balance of my time.
Thank you. Gentlelady's time has expired. Do any Republican members seek recognition? I don't see any. If not, does the gentleman from New York, Mr. Espiat, seek recognition? I understood he did seek recognition, but apparently it's not available. If not, then the order of business now is the question, are there any amendments to the amendment in the nature of a substitute? Chair recognize, does the gentleman from North Carolina, ranking member, seek recognition?
Yes, Mr. Chairman, I have an amendment at the desk.
Clerk will report the clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 3110 offered by Ms. Fox. And the code is R-Pump Act-ANS.
Gentlelady is recognized for 5 minutes on behalf of her amendment.
Thank you, Mr. Chairman. I rise today to offer a Republican substitute amendment to HR 3110, the Pump for Nursing Mothers Act. My fellow Republican committee members and I support existing protections in federal law for pregnant nursing mothers. But expansions that fail to deliver responsible, workable results are not worthy of the constituents we serve. And unfortunately, such is the case with key portions of the bill we're discussing today. The purported goal of HR 3110 is to expand access to accommodations for nursing mothers in the workplace and improve health outcomes for mothers and their newborns. However, HR 3110 is overly broad and imposes unworkable and unnecessary burdens on certain employers. For example, it applies a one-size-fits-all treatment of all workplace facilities, even those that lack the resources and physical infrastructure to accommodate some of the bill's requirements, such as transportation-based locations, including airplanes. Additionally, the bill mandates excessive penalties on employers for non-compliance. The Republican amendment replaces this flawed scheme by including workable and common sense alterations to the Fair Labor Standards Act to break time accommodation requirements, including further coverage for nursing mothers. The amendment modifies current law by providing these workplace accommodations to white-collar, executive, administrative, and professional employees, including academic personnel and teachers in elementary and secondary schools, while also maintaining current law coverage of non-exempt or hourly employees. This ensures that workers in a broad array of workplace locations and professions have access and accommodations for pumping. Furthermore, HR 3110 significantly increases the penalties for employer violations of required accommodations for nursing mothers. These penalties are not proportionate with the types of potential FLSA breastfeeding accommodation violations under the bill. The Republican amendment, in addition to maintaining current law remedies for violation, would address these concerns by preserving the authority of the Secretary of Labor to enforce compliance and punish offenders through the assessment of civil monetary penalties for repeat and willful violations. This provision will ensure that employers who violate breastfeeding accommodations are met with proportionate penalties for those actions. HR 3110 also implements a convoluted requirement that an employee is owed compensation for the entire length of a break in the event they are not entirely relieved from duty for the duration of it. This new requirement will create significant ambiguities and challenges in the modern workplace by failing to account for passive work time, such as email, phone use, or radio monitoring. In response, the Republican amendment clarifies that a break for nursing and pumping is non-compensable only when a mother does not actively engage in work. It also clarifies that nursing mothers who engage in work during a break will be compensated appropriately. The clarifying language in this amendment is important because HR 3110 fails to account for the privacy needs of nursing mothers, creating conflicts between maintaining the private nature of time spent pumping breast milk while also requiring employers to monitor whether work is performed or not. The amendment therefore creates a workable standard for business owners with clear guidelines for when compensation is necessary during a break without violating nursing mothers' privacy. Lastly, the amendment includes an alternative dispute process to allow employers to correct any violations within 30 days before enforcement proceedings begin, and also maintains the 50-employee undue hardship provision found in existing law to protect smaller businesses and requires a Government Accountability Office report to Congress to evaluate the implementation of the amendment's provisions. The common sense provisions in this amendment reflect our shared bipartisan goal of protecting working mothers, recognizing they have unique needs that demand unique accommodations in the workplace, and that employers need clarity and workable requirements after these accommodations. I hope my Democrat colleagues will see past partisanship to support this amendment. I urge a yes vote and yield back.
Thank you. Thank you. Does the gentlelady from Pennsylvania, Ms. Wild, seek recognition?
I do, Mr. Chair. Thank you very much.
Gentlelady's recognized for 5 minutes to strike the last word.
Thank you, Mr. Chairman. I am opposed to this amendment that would delay much needed common sense workplace protections for nursing moms by limiting remedies available to workers and by delaying the effective date of new remedies available to currently covered workers. This ANS does not appear to be viable or well-reasoned. In fact, on page 4, lines 14 to 21 are just the same instructions repeated over and over. This is indicative of the minority's overall apathy toward worker protections during a time when American workers are crying out for relief. But if we are reading it as drafted, it appears that the minority is seeking to allow the Labor Secretary to have another avenue of going to court on the workers' behalf. We welcome the opportunity to work with the minority to make this happen if that is the intent. This amendment goes to the heart of our work here today to protect the health of babies and moms. Under current law, workers generally cannot recover in court when their employers fail to comply with break time and space requirements for nursing mothers. They are only able to recover for unpaid minimum wage or overtime compensation in court for violations of break time and space requirements for nursing mothers. This leaves them unable to recover if they experience economic, health, or emotional harm. Allowing for legal and equitable remedies would help workers recover appropriate types of relief within well-established guardrails. One study that examined 8 different types of state breastfeeding support laws found that the single most impactful law that increased breastfeeding rates at 6 months postpartum was a workplace pumping law with an enforcement mechanism. Furthermore, the ANS, which has the support of the U.S. Chamber of Commerce, I might add, would make sure that employers have a heads up before a lawsuit and have 10 days to respond to a complaint. Allowing for compensatory and punitive damages does not mean unlimited damages. Compensatory damages are limited to the harm suffered by the individual. Punitive damages help to deter unscrupulous employers from harming workers to gain a competitive advantage. Often, without punitive damages, a business may treat its labor violations as merely a cost of doing business. Courts have an established practice of awarding justifiable damages, and under this bill, relief would only be provided as may be appropriate to effectuate the purposes of the bill. Artificial caps on damages mean that workers who have proven in court that they have been denied protection are unable to recover for the full extent of their harm. And what's more, this amendment would delay needed protections for currently covered workers. Break time and space protections have been on the books for more than 10 years. So employers should already be in compliance with respect to currently covered workers. The effective date for the expansion of available remedies only applies to currently covered workers. Currently, employees are only able to recover for unpaid minimum wage or overtime compensation in court for violations of break time and space requirements for nursing mothers. But in most circumstances, as the Labor Department has noted, there will not be any unpaid minimum wage or overtime compensation associated with a failure to provide such breaks. This amendment weakens the purpose of the bill to promote mothers' ability to breastfeed, to care for their children's health, and to look after their own health. I urge my colleagues to vote no on the amendment. I yield back, Mr. Chairman.
Thank you. Are there others who seek recognition? If not, I'll recognize myself very briefly just to say that this wide-ranging amendment really sabotages the compromise achieved by long discussions between the advocates, the health experts, and the Chamber of Commerce, and therefore should be just rejected on that basis alone, in addition to the points that the young lady from Pennsylvania has made. Are there any other comments on the amendment? If not, the question is on the amendment offered by the ranking member from North Carolina. All in favor of the amendment will say aye.
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 All opposed will say no.
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 It appears that the noes have it.
Mr. Chairman, on that, I'd request a recorded vote.
Recorded vote has been requested, and pursuant to prior comments, that vote will be rolled to the end. Are there other amendments?
Mr. Chairman,
Gentleman from Michigan, for what purpose does the gentleman from Michigan seek recognition?
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 3110 offered by Mr. Levin of Michigan. The code is LEVIMI_031.
Gentleman is recognized for 5 minutes on behalf of his amendment.
Thank you so much, Mr. Chairman. I'm thrilled that we're considering this bill today, and I'll be proud to cast my vote for it. When we talk about workers who might need to express breast milk at work, we're all likely thinking about those who've given birth recently and are now breastfeeding a new baby. As the dad of 4 kids who were each breastfed for between 1 and 2 years by my beloved wife, whether she was staying home or out working in the economy, that's certainly my first reference. And while, of course, we want to make sure those workers have the protections outlined in this bill, I think it's important to recognize that they're not the only workers who might need them. Workers who've experienced a stillbirth, who adopt or place their baby for adoption, or who serve as or have a baby through a surrogate. All of these workers might also need to express breast milk at work, and all of them deserve the same protections. My amendment simply clarifies that the break time and space protections in this bill apply to workers who've experienced a stillbirth and, in the case of adoption or surrogacy, apply to both the adoptive and biological mother. Some of these experiences might be difficult or even tragic for a mother. We have the chance today to make a simple change that perhaps can make their circumstances just a little less hard to get through. My amendment also lengthens the duration of the break time and space protections for nursing mothers from 1 year after the infant's birth to 2 years. After 6 months, the American Academy of Pediatrics recommends continued breastfeeding as foods are introduced, with continuation of breastfeeding for 1 year or longer as mutually desired by mother and infant. This is a personal decision for mothers, and it should be made based on what's best for mom and baby. As I mentioned, in my family, my wife decided to breastfeed all of our kids well past 1 year. That's a decision that should not hinge on the protection a workplace may or may not have for mothers. Today, we have a chance to protect moms in the workplace and to do so in a way that does not put a heavy burden on employers. In fact, the U.S. Chamber of Commerce takes no issue with either of the policies in this amendment. They're just common sense. Again, I'm so glad this committee is putting these protections in place and to have this opportunity to make sure those protections cover every worker who needs them. I urge my colleagues to vote for this amendment, and I yield back.
Thank you. Gentleman's time has expired. Does anyone seek to be recognized on the amendment? The ranking
Mr. Chairman.
Ranking member, Dr. Fox is recognized for 5 minutes on the amendment.
Thank you, Mr. Chairman. I appreciate very much Mr. Levin's very articulate presentation on behalf of this amendment. And I want to assure everyone that committee Republicans share the goal of improving accommodations and conditions for working mothers and have long advocated for flexible workplace policies to enable individuals to meet family and work obligations better. While I have no objections to this amendment, I will point out that it adds a new employer mandate conflicting with requirements under current law and the recommendation of experts. The 1 year period for nursing accommodations in current law is endorsed by the American Academy of Pediatrics and has worked well for nursing mothers and employers. The amendment also includes a sensible provision to expand eligibility for break time under HR 3110 to all women who are pumping breast milk, including those in the event of an adoption or the unfortunate circumstance of delivering a stillborn, which I support. Support for common sense policies that empower working mothers can and should be bipartisan. Unfortunately, again, a number of provisions in the underlying bill remain problematic. Therefore, I am hopeful that Republicans and Democrats can work together to make needed and common sense improvements to HR 3110, including those in our Republican substitute amendment before the bill is brought to the floor. This way, we can ensure the best possible solution for nursing women while also recognizing they have unique needs that demand unique accommodations in the workplace and that employers need clarity and workable requirements in offering these accommodations. And with that, Mr. Chairman, I yield back.
Does anyone else seek recognition? If not, I'll recognize myself very briefly. just to be able to yield to the sponsor of the amendment, Mr. Levin, to respond. Did you indicate that this had been cleared with the Chamber of Commerce, that they have no objection to it?
Yes, Mr. Chairman, the Chamber of Commerce has no objection to this. I just don't see the need to make everything into a partisan struggle. This is about moms breastfeeding their kids, my friends. And it's not an undue burden on business, according to the Chamber of Commerce. So I hope we can proceed collegially. And with that, I yield back.
Thank you. Reclaiming my time, and I yield back the balance of my time. Anyone else seek recognition? If not, the question is on the amendment offered by the gentleman from Michigan, Mr. Levin. All who favor the amendment will vote aye.
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 All who oppose will say no.
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 The ayes appear to have it.
I request the recorded votes, Mr. Chairman.
Who's requesting a vote? I'm sorry.
Mr. Good, I request
Okay, Mr.
recorded
Good.
vote.
Okay, Mr. Good asks for a recorded vote. A recorded vote will be, is ordered and will be rolled to the end. Are there any other amendments? If not, the next order of business is the roll call, would be the roll call votes that are on amendments and final passage of the bill, and that will be taken up at the end. The committee will now proceed to the consideration of the bill HR 2062 for amendment. The bill was circulated in advance and the clerk will designate the bill.
HR 2062 to amend the Age Discrimination in Employment Act of 1967 and other laws to clarify appropriate standards for federal employment discrimination and retaliation claims and for other purposes.
Without objection, the first reading of the bill is dispensed with. And without objection, the bill will be considered as read and open for amendment at any point, and any amendment offered shall be considered as read. I'll now recognize the gentlewoman from Oregon, Ms. Bonamici, to offer for the purpose of offering an amendment.
Thank you, Mr. Chairman. I have an amendment in the nature of a substitute at the desk.
The clerk will designate the amendment in nature of a substitute.
Amendment in the nature of a substitute to HR 2062 offered by Ms. Bonamici of Oregon. The code is H2062_001.
Thank you. And without objection, the amendment shall be considered original text and open to amendment at any point. The amendment, the nature of a substitute, was distributed electronically in advance. I'll now recognize the gentlelady from Oregon for 5 minutes on behalf of her amendment.
Thank you, Mr. Chairman. Americans are living and working longer, and we must do all we can to make sure they are protected from age discrimination. Unfortunately, age discrimination is still disturbingly pervasive. According to the AARP, approximately 61% of older workers have either seen or experienced themselves age discrimination in the workplace. My home state of Oregon has one of the most rapidly aging populations in the country. And I've heard from workers, particularly those in the technology industry, who believe they have been dismissed or denied employment because of their age. Now, my office has helped older workers who have filed age discrimination complaints before the Equal Employment Opportunity Commission, but the burden of proof is very high and often results in uncertain outcomes. According to a study from the Urban Institute in ProPublica, more than half of older workers are pushed out of long-time jobs before they choose to retire, and only 1 in 10 of those workers earns as much as they did before their involuntary separation. And the COVID-19 pandemic and resulting economic consequences have only made this financial hardship more jarring. A recent study found that for the first time since 1973, older workers face higher unemployment rates than their mid-career counterparts. Unfortunately, age discrimination is a significant factor in older workers' long-term unemployment. Congress recognized the need to protect older workers from discrimination when it enacted the Age Discrimination in Employment Act of 1967. But in 2009, the Supreme Court's decision in Gross versus FBL Financial Services, Inc. imposed a much higher burden of proof for workers to prove age discrimination under the ADEA. Because of the court's holding in Gross, workers must now prove that age discrimination was the decisive cause for their employer's adverse action, rather than just a motivating factor in their employer's adverse action. Earlier this year, I joined Chairman Scott in reintroducing the Bipartisan Protecting Older Workers Against Discrimination Act. This bill is a bipartisan legislative fix that would restore the pre-2009 standard in age discrimination claims and align the burden of proof with the same standard that's used for proving discrimination based on sex, race, religion, and national origin. As we discussed during the joint Civil Rights and Human Services and Workforce Protection Subcommittee I chaired earlier this year, as well as in the hearing on the Protecting Older Workers Against Discrimination Act that we held last Congress, this bill is a very important step to protect older workers from discrimination in the workplace. It would make congressional intent clear in the law. Any unlawful discrimination in the workplace is unacceptable. This bill is a product of bicameral and bipartisan negotiations, and the amendment in the nature of a substitute only makes a minor technical change, actually, to the name of the bill. So I urge my colleagues to support this amendment and the underlying bill, and I yield back the balance of my time, Mr. Chairman.
Thank you. Does anyone seek recognition on the amendment?
Yeah. Glenn Grothman.
Gentleman from South Carolina, Mr. Wilson was on our list, and we have Mr. Levin and Mr. Grothman after that. Mr. Gentleman from South Carolina, Mr. Wilson, if you're unmuted and recognized for 5 minutes.
Hey, thank you, Mr. Chairman. Committee Republicans believe that discrimination in any form is wrong, and there should be equal opportunity for everyone. However, we also believe that laws should not only change when there's a compelling evidence that change is actually needed and when it's beneficial to those it purports to help. Most frequently, enforcement of current laws negates the need for new laws. Unfortunately, the Democrats Protecting Older Workers Against Discrimination Act in their amendment and the nature of a substitute falls embarrassingly short of that standard. The bill and the amendment and nature of substitute are nothing but an invitation to lawsuit abuse. Ensuring that American workers, regardless of age, are protected and reasonably accommodated should be a responsibility we take seriously and thoughtfully. On HR 2062, the committee Democrats did not even schedule a standalone hearing to gather information from experts on whether it's needed or workable. Democrats argue the bill is necessary after the Supreme Court's decision in the Gross case of 2009, 12 years ago. Workers have been discouraged from filing age discrimination charges, they claim, in lawsuits. However, the one and only Democrat invited as a witness, we did have the opportunity to hear on this issue, admitted, quote, "It is difficult to quantify the impact that the Gross decision has had on the number of older workers who bring cases and the number of those who win them," end of quote. Moreover, we do know that the age discrimination charges filed with the Equal Employment Opportunity Commission, EEOC, as a percentage of all charges have remained steady for the 11 years before and after the Supreme Court issued the Gross decision. This fact undercuts one of the Democrats' key arguments in favor of the bill. There has also been an uptick of retaliation charges filed with the EEOC since the Supreme Court's decision of the Nassar case, indicating that contrary to the Democrat talking point, employees have definitely not been discouraged from filing these charges that the case was decided, since it was decided. Additionally, if this bill passes, it will amend the Americans with Disabilities Act in a harmful way. As it stands now, an employer is supposed to work with an employee seeking an accommodation to determine the appropriate reasonable accommodation. A flexible, interactive dialogue between an employer and an employee is the most effective way to determine an accommodation. If an agreement on a reasonable accommodation cannot be reached under HR 2062, that alone may be enough for an employee to demonstrate discrimination. This will greatly harm the relationship between employees and their employers and prevent employees from receiving accommodations in a timely manner. To pass a bill that discourages dialogue between both parties is disruptive and counterproductive. Sadly, we're here today discussing costly, sweeping legislation that will overturn decades of Supreme Court precedent before we even know whether it's necessary or appropriate. What we do know, however, that this bill will encourage more employees to file lawsuits that will not provide them monetary compensation or other significant remedies, while resulting in endless paydays of legal abuses. This is a counterproductive way to legislate and a waste of time and resources. I urge all my colleagues to vote no on the amendment and no on the underlying bill. I yield back.
Thank you. I have Mr. Levin and then Mr. Courtney on our side. We'll go first with the gentleman from Michigan, Mr. Levin.
Thank you, Mr. Chairman. I move to strike the last word.
Yep. Gentleman's recognized for 5 minutes.
Thanks, Mr. Chairman. I'm really very happy that we're considering the Protecting Older Workers Against Discrimination Act, or POWADA. This is a common sense and bipartisan piece of legislation that ensures older workers can fight for their rights. The Supreme Court decision in Gross reversed nearly 30 years of precedent and instituted a new heightened but-for standard to proceed with claims of age discrimination in the workplace. That means under the Gross standard, unless you could demonstrate that age was the sole cause for an employer's adverse action, a worker who's faced discrimination because of their age cannot have their day in court. I remember so clearly, Mr. Chairman, meeting victims of age discrimination just after the Gross decision came down. I was Michigan's chief workforce officer at the time. I created a program called No Worker Left Behind to help workers who were unemployed and underemployed during the Great Recession to go back to school to earn degrees and certificates so they could restart their careers. And I can't tell you how surprised I was by the number of older workers who came forward because they had lost their jobs. And one guy particularly sticks in my mind. He was a store manager in Bay City, Michigan. He had been in college many years before, and his dad died of a heart attack. And his mom said, "Son, I'm sorry, you got to go to work." And he worked his way up in retail. And then he was a store manager in his mid-50s. And basically, the company looked at him and said, wait a minute, we could get some person much younger to work for half the salary, and they just got rid of the guy. And that is wrong. But they can come up with a pretext, and there's nothing he could do. And that's why we've got to pass POWADA. It undoes the Supreme Court ruling and goes back to a legal standard that was in effect for nearly 3 decades and worked very well. I'm glad this bill has bipartisan support, but you know, Mr. Chairman, I don't see any reason why every member shouldn't be supporting it here today. I think we all understand that it's wrong to fire or mistreat a worker because of their age, like that guy from Bay City. And we all know that it's easy to come up with some pretext and say, that wasn't the only reason. Now we have an opportunity to do something about it. You know, Mr. Chairman, politicians like to say that they represent the working class. Well, supporting the working class doesn't mean putting on a hard hat and going on a factory tour. It means ensuring that workers are empowered to fight discrimination in their workplaces. This bill restores that power for older workers. I urge all of my colleagues to vote in support of the bill, and I yield back the balance of my time.
Thank you. The next speakers we have are Mr. Grothman and Mr. Courtney. Mr. Gentleman from Wisconsin, Mr. Grothman, do you seek recognition? Are you on mute?
There I am. I can hear me?
Yep, yep.
Okay,
Gentleman's recognized for 5 minutes to speak on the amendment.
yeah, age discrimination is a big problem. I may even be co-sponsor of this bill. But I wish before we had a hearing, or before we voted on it, we had a hearing for this reason. Congressman Levin wondered why anybody would be opposed to this bill. Usually when you file discrimination complaints, you can go federal or you can go state. And I was very involved in this at a state level. Overwhelmingly, discrimination claims are ruled to be frivolous at the first level. And usually that determination is made by, I think, state or federal employees who are predisposed to say discrimination is going on, like Congressman Levin. And I would hope that to try to be open-minded, eventually this committee do something to deal with the huge number of claims which do not have merit and are even frivolous. As I understand it, most discrimination claims are filed when someone gets let go and kind of get back at the employer, they say discrimination. But in any event, this is just a request of our wonderful chairman, who I think so highly of, that eventually we have a hearing on this topic and find out how many discrimination claims don't make it even by the first hurdle, and how many of those would be described as frivolous, and what we can do to prevent that. So thank you very much for indulging me.
Thank you. I would let the gentleman know we'll try to get that information as quickly as we can, in addition to the fact that we've had hearings on the legislation in this Congress and in past Congresses, but we will get that specific information as soon as we can. The gentleman from Connecticut, Mr. Courtney, do you seek recognition?
I do, Mr. Chairman. And again, just to make a brief
The gentleman's recognized for 5 minutes. So strike the
Thank you. Just make a couple brief comments. Again, I think Mr. Levin did a nice job, with his own personal experience, sort of, reminding us of what the fundamental intent of this law is, which is that when the Civil Rights Act was passed back in 1964 and set up, protections for employment discrimination, there were a number of categories which the Congress cited as needing that type of assistance: race, religion, sex, national origin, and age. And the standard or the threshold for employees or workers to make a claim of discrimination has been the mixed motive standard, which basically said that an employee needs to show that it was a significant factor in terms of termination or demotion or whatever. And then the employer then has an opportunity to rebut that. What the court did in 2009 was it basically untethered age from the other populations covered by the Civil Rights Act and basically raised the burden of proof to require that the workers show that but for age discrimination, that they would be entitled to an award. And that's almost an impossible standard to satisfy. So it was a 5-4 Supreme Court decision. We've heard from, again, credible sources like AARP in terms of the fact that this problem has not, been solved because of the Supreme Court decision. I think, Joe Wilson's citing of the number of claims that's still flooding in shows that, in fact, this is a real problem that still exists there. The fact that they're not prevailing is partly because of the Gross decision. And that's really what we have an opportunity to restore, which just, again, aligns the standard of proof that's created under the Civil Rights Act to basically be on par with race, religion, sex, and national origin, period. Full stop. That's what we're doing here. And that's not unprecedented for Congress to wade back in and deal with, a Supreme Court decision, which they felt basically, which we feel basically tipped the scales in an unfair fashion. The Lilly Ledbetter law, which was signed into law back in 2009, was in response to a Supreme Court decision, Ledbetter versus Goodyear Tire and Rubber, which basically set up a totally, unfair Mickey Mouse chutes and ladder rule for women who were trying to get justice in terms of wage discrimination, and we fixed that. That's what we said. Thank you to the Supreme Court. See your, note your decision, but we're going to, fix what the court's erroneous interpretation of what Congress intended with wage discrimination, and that is precisely what we're doing here, which was we're basically saying that age is a significant area of human life which none of us have control over, and that people should not be discriminated because of age, just like we do not allow discrimination to occur for race, religion, sex, and national origin, and they should be treated the same in terms of bringing a discrimination case. So again, I am pleased that we had a decent, solid bipartisan majority last time this bill came up in the last Congress, and hopefully we'll grow that number, because we're obviously in a situation right now where the employment participation rate is really struggling because of the pandemic and the recession. And frankly, we want, all hands on deck in terms of getting this recovery going. And certainly older workers have a lot to contribute to getting, again, this country back on its feet. And with that, I yield back.
Thank you. Does anyone else seek recognition? I don't see any other names. There appearing to be no further discussion on the amendment in nature of a substitute, the committee will now consider amendments to the amendment in nature of a substitute. Does any member wish to offer an amendment? The gentlelady from North Carolina.
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment at the desk.
Clerk will designate the amendment.
Amendment to the amendment and the nature of a substitute to HR 2062 offered by Ms. Fox of North Carolina. The code is H2062_004.
Gentlelady is recognized for 5 minutes on behalf of her amendment.
Thank you, Mr. Chairman. For an employer to retaliate against an employee because that employee has previously made a discrimination complaint is wrong, and it is already illegal. However, HR 2062 reduces the standard of proof in retaliation cases by allowing mixed motive claims, overturning the Supreme Court's 2013 decision in the Nassar case. This provision is particularly ill-advised. Justice Anthony Kennedy wrote in the majority opinion in Nassar that in retaliation cases, quote, lessening the causation standard could contribute to the filing of frivolous claims, which would siphon resources from efforts by employers, administrative agencies, and courts to combat workplace harassment, end quote. Justice Kennedy also wrote in his opinion that the concern about diverting resources was especially true because retaliation charges filed with the EEOC had nearly doubled in the past 15 years and had become the second most frequently filed category of complaint. This concern is even more relevant today because the retaliation is now the most frequently filed EEOC charge. Allowing mixed motive claims in retaliation cases is unworkable and contrary to the text, structure, and history of Title VII, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. All retaliation claims are inherently about differing explanations. In these situations, the plaintiff has already made a discrimination complaint, and under the mixed motive standard, it will be a mere formality to plead the subsequent employment action in question was retaliatory. Under HR 2062, a plaintiff will always survive the summary judgment stage of the litigation, and the case will either settle or go to trial, increasing the number of frivolous claims and related financial costs noted in the Supreme Court decision, while reducing important resources that would otherwise be used to combat discrimination. In addition, It may surprise most plaintiffs to learn that in nearly all mixed motive cases under HR 2062, they will be awarded no monetary damages and will not be entitled to reinstatement. The only ones to be paid in the vast majority of these cases will be the plaintiff's lawyers. There's no evidence to support the claim that employees have been harmed by the Nassar decision. Individuals have not been discouraged from filing retaliation charges with the EOC, and they still win lawsuits claiming retaliation. And by the way, when employees win lawsuits claiming retaliation under the current standard, they can receive monetary damages, back pay, and reinstatement, as well as attorney's fees and costs. Under HR 2062, nearly all successful plaintiffs will not receive any monetary damages, pay, or reinstatement. Only the trial lawyers get paid. This amendment strikes the unworkable and ill-advised provisions of 2062, allowing mixed motive claims and retaliation cases, which will keep in place the current standard of proof as described in the Nassar case, and committee members are urged to support it. And with that, Mr. Chairman, I yield back the balance of my time.
Thank you. Does anyone wish to speak to the amendment? Does the gentlelady from Oregon seek recognition?
Yes, thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized for 5 minutes on the amendment.
Thank you, Mr. Chairman. I oppose this amendment. The Supreme Court's Gross decision replaced the mixed motive standard with, as we heard, a more stringent but-for evidentiary standard, which significantly weakened a claimant's recourse for age discrimination. The but-for test means that claimants must prove that the unlawful discrimination was the sole or but-for cause of the adverse action. And since the Gross decision, both the Supreme Court and some lower courts have relied on and applied the Gross reasoning to other civil rights laws, which is why we need this Protecting Older Workers Against Discrimination Act. In the University of Texas Southwestern Medical Center versus Nassar, the Supreme Court applied the but-for standard to retaliation claims under Title VII of the Civil Rights Act. And notably, the court referenced the 2009 Gross decision involving the ADEA as part of its rationale. The Nassar decision resulted in the unequal treatment of claims under Title VII of the Civil Rights Act as 1964, as Mr. Courtney so eloquently explained. It does not make sense to have separate provisions of Title VII requiring different standards of causation, discrimination based on protected class using a mixed motive standard, and the anti-retaliation provision applying a but-for standard of causation. And this is exactly why Protecting Older Workers Against Discrimination Act is so important. This bill is and I just want to emphasize this bill is a legislative fix needed to simply restore the mixed motive standard to retaliation claims under Title VII of the Civil Rights Act, the Age Discrimination and Employment Act, the Americans with Disabilities, and the Rehabilitation Act, simply restoring the standard to what it was before the Gross case. The enforcement of civil rights laws relies on individuals to assert their rights. And by retaining the but-for standard for retaliation claims, this amendment would make it far more difficult, and it's already difficult, for workers to secure justice. I urge my colleagues to oppose this amendment, and I yield back the balance of my time.
Thank you. Does anyone else seek recognition? If not, the question is on the amendment offered by the gentlelady from North Carolina, the ranking member. All who favor the amendment will say aye.
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 All opposed will say no.
No.
Oh,
Oh,
The noes appear to have it.
Mr. Chairman, on that, I request a recorded vote.
Recorded vote is requested. Are there other amendments? Does the gentleman from Georgia have an amendment?
Yes, Mr. Chairman, I have an amendment, Allen H2062 underscore 003 at the desk.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 2062 offered by Mr. Allen of Georgia with the code that Mr. Allen stated.
Thank you. The gentleman from Georgia is recognized for 5 minutes on this amendment.
Thank you, Mr. Chairman. When considering any legislation, this committee should first determine whether the legislation is needed, and next, whether the bill under consideration will adequately address or improve the situation. The committee did not have a standalone hearing on HR 2062 and only heard from one witness invited by the Democrats about the bill at a hearing on multiple wide-ranging topics. This complex and sweeping legislation, at the very least, deserves a separate hearing so that committee members can gather more information from a variety of experts to make a considered decision regarding its viability. Publicly available data does not show that the Supreme Court decisions in Gross or Nassar have discouraged individuals from filing EEOC charges. The Democrat invited witness who testified at the March 18 hearing in favor of HR 2062 acknowledged that it is difficult to quantify the impact that the Gross decision has had on the number of older workers who bring cases and the number of those who win them. This witness also acknowledged at a committee hearing in 2019 that when we might have expected a drop in charges due to Gross-inspired discouragement from employment attorneys, there was a sizable jump in the number of ADEA charges filed with EEOC. A review of EEOC data shows that the rate of EEOC age discrimination charges as a percentage of all charges filed is approximately the same for the 11 years before and after the Gross decision, which is a slightly higher percentage of age discrimination charges filed as a percentage of all files after the Gross decision. In addition, there has been an uptick in Title VII retaliation charges as a percentage of all charges filed in the 7 years following the Nassar decision, which does not indicate individuals have been discouraged from filing these charges. A review of court decisions shows that plaintiffs have continued to win age discrimination and Title VII retaliation cases in the wake of the Supreme Court's decisions in Gross and Nassar. To summarize, this amendment will provide Congress much needed data on the impact of the two Supreme Court cases at issue in HR 2062. If the GAO report indicates the Gross and Nassar decisions have not discouraged individuals from seeking relief or from achieving it, the bill will not be necessary. This committee should look before it leaps, and members should vote in favor of this amendment to ensure this legislation is actually needed and adequately addresses the purported concerns of the bill sponsors. I yield back the balance of my time.
Thank you. Does anyone seek recognition on the amendment? Gentleman from New York, Mr. Jones, do you seek recognition?
Yes, Mr. Chairman.
The gentleman's recognized for 5 minutes to strike the last word.
Thank you, Mr. Chairman. I oppose my Republican colleagues' amendment mandating a study before this bill can go into effect. This is unfortunately not an earnest attempt to look into the issue of age discrimination. It is rather a tactic of delay and nothing more. We know that age discrimination happens, and this is a problem that harms not just workers, but the economy at large. Age discrimination is one of the most common and sadly most accepted forms of discrimination in the workplace. Last year, the EEOC received over 14,000 age discrimination complaints, accounting for over 20% of all discrimination charges filed in this country. These statistics underscore the prevalence of age discrimination. Further, it should be obvious that we don't need a study to tell us that a substantially higher burden of proof for some forms of discrimination makes it more difficult for workers who can prove discrimination to get their day in court and to prevail. That's just common sense. We urgently need to return to a mixed motive standard, which says that any consideration of age, as opposed to ability to perform a job, is impermissible in employment decisions. We can look at two cases that were proceeding under a mixed motive standard, but were dismissed following the Supreme Court's precedents as examples. Courts dismissed both of these cases on the grounds that the facts, which were sufficient under a mixed motive standard, were no longer sufficient under the heightened but-for standard. First, there's the case of Jack Gross, an older gentleman who had been demoted after refusing a buyout when his employer underwent a merger. As he and many older workers were demoted, his younger colleagues received promotions. Mr. Gross challenged his demotion under the Age Discrimination in Employment Act and won his case at trial under the motivating factor framework. However, after the Supreme Court changed the rules and required him to retry his case under the new and more stringent but-for causation standard, he lost, despite the fact that he had proved the same set of facts with the same parties in the same courts as before. Second, consider the impact of the Nassar case on anti-retaliation claims under the Civil Rights Act. In the case of Shamati v. Selma City Board of Education, an elementary school cafeteria worker alleged that she had been passed over for promotion due to having filed earlier discrimination claims, and that those claims had been discussed by the interview panel. The district court denied the employer's motion for summary judgment on her retaliation claim. However, the Nassar decision was issued a few months later, and then the employer moved for reconsideration under the new causation standard, this time stating that the Supreme Court has changed the rules since then. The district court dismissed the worker's retaliation claim and granted summary judgment to the employer. Same facts, same case, different causation standard, and a win was turned into a loss. The court's decisions in Gross and Nassar have clearly impacted older workers negatively. You do not need a study to determine that when cases become materially more difficult to win, attorneys become much less willing to represent workers in these cases. The Protecting Older Workers Against Discrimination Act reinstates the legal standard for proving age discrimination and aligns it with the existing standard for proving discrimination based on sex, race, or national origin. There is simply no excuse for discrimination of any kind in the workplace, and there's no reason to delay this legislation any further. We have already done that for 12 years, and it has blocked us from restoring justice. This proposed amendment, by the way, has no deadline for GAO to conduct the study and report back to Congress. It is simply intended, as I mentioned earlier, to delay implementation indefinitely. And for these reasons, I urge my colleagues to reject the Allen Amendment. I yield back.
Thank you. Are there other comments on the Allen Amendment?
Mr. Chairman.
Gentlelady from Oregon.
Thank you, Mr. Chairman. I just request to strike the last word, move to strike the last word.
Recognized for 5 minutes on the Allen Amendment.
Thank you, Mr. Chairman. I just want to align myself with the remarks of Mr. Jones, and I thank him for bringing up Mr. Jack Gross. Mr. Gross actually attended the hearing we had in the last Congress on the Protecting Older Workers Against Discrimination Act. And if he's listening today, I just want to say, Mr. Gross, we hear you. We understand how frustrating it's been. And as Mr. Jones clarified, he had won his case until the Supreme Court changed the standard that had been around for years. So that's the reason why we're doing the Protecting Older Workers Against Discrimination Act today, is to restore the standard that gave workers who have been discriminated against based on age a chance, a fighting chance to actually receive justice. And I yield back the balance of my time.
Thank you. Others wish to speak to the Allen Amendment? If not,
Mr. Chairman.
Gentleman from California, Mr. Takano.
Mr. Chairman, I too, thank you, Mr. Chairman, for recognizing me. I too remember.
Does the gentleman seek recognition?
Yes, I do.
Gentleman, recognized 5 minutes.
I move to strike the last word. I too recall that testimony on that by Mr. Gross to the subcommittee. There were hearings on this very topic, which went into depth, and my heart goes out to Mr. Gross's frustration, and I too remember the testimony he gave. Look, Americans are working longer, unfortunately, because they have to, and we need to make sure that that opportunities for older Americans to be able to continue to work and to continue to be eligible and recognized for their long experience and their competency does not go by the wayside because of a Supreme Court decision, which threw out the mixed motive standard. I agree with Mr. Jones, and I associate myself with his remarks regarding a need to return to that standard. And, justice in America should not be dependent on whether or not we have people filing claims or not. The law should be set so that it is a recourse for those folks, for those individuals who are discriminated against. And that's not a matter of how many people have filed claims. More people will file claims as employers act unjustly. Less people will file claims when workers do not have to face unjust employers. So I reject this amendment. I will vote against it, and I urge my colleagues to do the same, and I yield back.
Thank you. The others wish to speak to the amendment? If not, the question is on the amendment offered by the gentleman from Georgia, Mr. Allen. All who favor the amendment will vote aye.
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 All opposed will vote no.
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 The noes appear to have it.
Mr. Chairman?
The gentleman from Georgia
Yes, I asked for a recorded
asked
vote.
for a recorded vote, and that will be rolled. The next amendment is the gentleman, my colleague from Virginia. And before I recognize my colleague from Virginia, we want to take note that our Commonwealth is in mourning today because of the passage of former Senator John Warner, who was probably the most important statesman that the Commonwealth has had for a long time. And so it's a sad day in the Commonwealth of Virginia. And so we ask for the committee members to pray on behalf of the John Warner family. My colleague from Virginia, Mr. Good.
Thank you, Chairman. I just want to add my prayers for the Warner family, and I appreciate you're taking the moment to recognize his longtime service on behalf of our Commonwealth and the people of Virginia. I do have an amendment to present, if I may.
The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to HR 2062 offered by Mr. Good. The code is H2062_002.
Thank you. The gentleman is recognized for 5 minutes on behalf of his amendment.
Thank you again, Mr. Chairman. Unfortunately, we're here today because of the majority's continued relentless attacks on employers from their demonstrated mindset that employers are evil, and left to their own devices, they will seek to harm their employees. But the fact is that the vast majority of employers are trying desperately to attract, recruit, and retain quality employees, and they want to foster a positive, healthy workplace. Furthermore, laws already exist to protect those employees that we purport today to help through the additional actions of the majority. In their zeal to show that they're doing anything, they're punishing job creators with more costly layers of regulations that do nothing to truly help the employees. HR 2062 will not achieve the goals espoused by the bill sponsors, and my amendment adds some much needed truth in advertising to this bad bill. The amendment adds a finding to HR 2062, pointing out that under the bill as written, most successful plaintiffs will not be entitled to any monetary damages, payments, or reinstatement, while those plaintiffs may end up owing income taxes on fees that are awarded to their attorneys. The Supreme Court in the 2009 Gross case eliminated a defense that allows the employer in discrimination cases to demonstrate it would have taken the same employment action in the absence of the impermissible factor of age. But HR 2062 actually restores this employer defense. An overwhelming majority of employers will be able to make this demonstration, and when they do, A plaintiff will not be entitled to any monetary damages, payments, or reinstatement. Only the employer's attorney will be paid. Therefore, the only party who wins in these cases are the trial lawyers. HR 2062 is specifically written to allow plaintiffs to survive a summary judgment motion that would end their case, but a plaintiff is in for a surprise later when he or she receives no monetary damages and the only one getting paid is his or her attorney. To add insult to injury, the employee may again have to pay income taxes on the fees that are awarded to his or her attorney. The bill and its sponsors never explain how adding the provisions that include mixed motive claims and restoring the same action employer defense will benefit employees. In fact, this provision will only help the trial lawyers. So I urge my colleagues to vote for this amendment to help clarify the unfortunate consequence of enacting HR 2062, and I yield back the balance of my time.
Thank you. Does the gentlelady from Pennsylvania seek recognition?
I do, Mr. Chairman.
Gentlelady is recognized for 5 minutes to strike the last word.
Thank you very much. I am opposed to this amendment that would insert a speculative and misleading finding to the Protecting Older Workers Against Discrimination Act. This amendment would undermine our work here today to protect older Americans from discrimination, and it runs against the spirit of ensuring equal justice is available to everyone, not just those who can afford it. Even if we could guarantee that this finding were true, it adds nothing to the bill, since our goal here today is to ensure that all claimants can receive justice for a meritorious discrimination case. The bill provides older workers with two avenues to receive justice. First, it would allow plaintiffs to prevail by demonstrating age discrimination under a mixed motive evidentiary threshold, rather than the extremely high burden of the sole or but-for standard that few workers who experience age discrimination can demonstrate. And second, if an employer can show that they would have taken the same adverse action, notwithstanding proof of unlawful age discrimination, damages and reinstatement will not be awarded, but injunctive and declaratory relief would be ordered, including attorney's fees that enabled the plaintiff to bring their case in the first place. This amendment runs contrary to the notion that employers can and should still be held accountable when plaintiffs partially prevail by demonstrating age discrimination, even if the employer can demonstrate that they would have come to the same outcome absent the discrimination. Injunctive and declaratory relief is the tool to cure discriminatory practices, a good outcome for future workers as we aim to build a society free of age discrimination. Our civil rights laws can only work if everyone and every worker has the ability to assert their rights. And that means that lawyers should not only be available to affluent workers. Moreover, the ADEA, ADA, Title VII of the Civil Rights Act, and the Rehabilitation Act all allow for reasonable attorney's fees, emphasis on the word reasonable. And I have to address the statement that has been made by my colleagues across the aisle on at least 2 occasions today, that attorney's fees recovered may be taxable to the plaintiff who may not actually see any recovery. That is patently false. Income taxes are paid by the recipient of the income, so that attorneys who receive attorney's fees have to pay their own taxes on those attorney's fees. It is absolutely, and I say this as somebody who over the years represented many people in employment cases, not only on the claimant side, but also on the employer side. It is absolutely false to say that the plaintiff has to pay income taxes on the attorney's fees. Courts and judges are well equipped to determine reasonableness for a particular case, far better equipped than politicians talking abstractions and misleading findings in a committee. This is an amendment based on speculation. It misleads the public about the importance of this legislation to older workers, and it would advance a false narrative that this bill is about lawyers rather than about workers' rights to economic security and dignity throughout their working life. And I urge my colleagues to vote no on this amendment.
Thank you. If the others seek recognition on the amendment?
Yes, Mr. Chairman, I move to strike the last word.
Okay, just a minute. Let's, anyone else? Okay, we want to make sure there's no one on the other side seeking recognition. Gentleman from New York, Mr. Jones.
Mr. Chairman, I oppose my Republican colleagues' amendment to add a finding on attorney's fees because it is simply unnecessary. Under the Age Discrimination and Employment Act, the Americans with Disabilities Act, the Rehabilitation Act, and Title VII of the Civil Rights Act, a successful plaintiff may recover, quote, reasonable attorney's fees. The Protecting Older Workers Against Discrimination Act does not change this. What we are seeing here is an attempt to flip the script and antagonize attorneys rather than address actual age discrimination. While my colleagues on the other side often argue that we need to cap attorneys' fees to help workers, doing so would only hurt them. A cap on attorneys' fees would put workers at a disadvantage in the courtroom. Reasonable attorneys' fees are presently set by judges who can assess the amount of effort, difficulty, and complexity involved in a particular case. Capping fees effectively eliminates the economic incentive for attorneys to take on complex or difficult to prove claims, particularly in cases of age discrimination. The result is less access to justice for employees seeking equal treatment from employers. On the other hand, a contingency fee arrangement enables a plaintiff to engage representation without a lot of upfront resources. Contingency fee arrangements also serve as a check on frivolous litigation because lawyers will not bring cases with no chance of recovery. In short, this amendment does nothing but add language to antagonize attorneys and undermine the intent of the Protecting Older Workers Against Discrimination Act. Congress should support equity for all workers. The underlying bill achieves that goal. For that reason, I urge my colleagues to stand up for older workers, disabled workers, and those who face retaliation from employers. I strongly oppose this amendment and urge my colleagues to vote no. I yield back.
The gentleman's yielded back. Are there others to speak to the good amendment? If not, the question is on the good amendment. All who favor the good amendment will vote aye.
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 All opposed will say no.
No, no.
It appears that the noes have it.
Mr. Chairman, I'm shocked that anyone would vote no, so I'm going to have to insist on a recorded vote, sir, please.
We'll see. We'll see what it looks like on the vote. The
sir.
recorded vote is requested, and that will be rolled.
Thank you, sir.
The next amendment is to be offered by the gentlelady from McLean. Does the gentlelady from, gentlelady from Michigan, Ms. McLean, do you seek recognition for the purpose of an amendment?
Yes, Mr. Chairman, I do. Thank you.
The gentlelady has an amendment at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 2062 offered by Ms. McLean. The code is HR 2062-RAM1.
The gentlelady from Michigan is recognized for 5 minutes on behalf of her amendment.
Thank you, Mr. Chairman. The amendment protects workers with disabilities by preserving the well-established process through which they receive workplace accommodations. The amendment clarifies that an employer merely engaging in dialogue with a worker with a disability to find a reasonable accommodation that is not sufficient itself without additional evidence to demonstrate discrimination under HR 2062. Under the Americans with Disabilities Act, when a worker requests an accommodation, the employer must make a reasonable effort to determine a reasonable accommodation. ADA regulations state that an accommodation is best determined through a flexible, interactive process between the employer and the worker to determine a reasonable accommodation. So they both sit down together. This is the most common way that the workers with disabilities are provided accommodations. They sit down, employer and worker, and hash it out. By allowing a mixed motive claim in the ADA cases, HR 2062 would severely undermine the interactive process, which would interfere with workers being provided accommodations. And this is because under the bill, merely engaging merely engaging in the interactive process with the worker by itself could be sufficient to demonstrate mixed motive discrimination. In the interactive process, the nature of the worker's limitation can be crucial to finding a reasonable accommodation. That's what we're all trying to do, is find a reasonable accommodation. There may be situations where the employer does not agree to a requested accommodation, or the worker does not accept an offered accommodation. But under the mixed motive theory, HR 2062 could create a presumption that the interactive process is by itself proof of a mixed motive because the worker's limitation is discussed, resulting in employer liability. This amendment simply clarifies that simply engaging in the interactive process without additional evidence is not sufficient to prove a mixed motive claim of discrimination under HR 2062. This amendment will protect workers by ensuring employers can freely engage in a dialogue with them to find reasonable accommodations. That's the whole goal, is to accommodate the workers. And by sitting down and having these dialogues leads to a better outcome. I urge my colleagues to support this amendment to protect workers with a disability, and I yield back the balance of my time.
Thank you. Does anyone seek recognition on the amendment? Gentleman from California.
Yes, Mr. Chairman, I move to strike the last word.
Gentleman from California is recognized for 5 minutes.
Well, this amendment tries to, what it does is the plaintiff may not rely solely on the fact that an employer has engaged in an interactive process with an employee or a job applicant to determine a reasonable accommodation. And the emphasis on reasonable. Well, this is not a very reasonable amendment. I'm going to tell you why. This amendment conflates the POWADA's attempt to clarify that discriminatory intent does not need to be the sole basis for a claim under anti-discrimination law with the complex questions regarding the circumstances under which the failure of the judicially created interactive process can form the basis for a lawsuit under the ADA. And I emphasize that the interactive process is a judicially created concept. Active engagement in the interactive process through which an employer and employee determine a reasonable accommodation is a critical piece of avoiding discrimination. There is no need to circumvent how courts determine the weight of the failure to engage in the interactive process. So an employer that fails to engage in the interactive process and denies a reasonable accommodation should be held accountable for such bad actions. They're being bad actors. Courts have had no difficulty determining the role of the interactive process as part of the basis for a lawsuit under the ADA. This amendment is unnecessary and potentially undermines the rights of plaintiffs under the ADA. And look, the last presenter of the amendment, the previous amendment, was surprised that his amendment went down. But I'm going to tell you, I am surprised the lengths to which the minority simply wants to undermine the advancement and the restoration of the rights of older Americans to have gainful employment that they're going to need, that many of them need. And whether they need it or not, whether people need it or not, they should be able to have a fair shake in the workplace and be able to have adequate resource in the courts when their rights to employment are denied or they're being treated unjustly. I'm amazed at the amendments we're seeing brought forward today. Mr. Chairman, I urge all my colleagues to vote no on this amendment. I yield back.
Thank you. Does anyone else seek recognition on the McLean amendment?
Chairman?
Gentlelady from North Carolina seeks recognition to strike the last word. She's recognized for 5 minutes.
Thank you, Mr. Chairman. You know, like my colleagues, I'm opposed to this amendment and to the earlier Fox amendment more broadly. We've heard a lot about mixed motive standards today, a standard that we know will afford older workers the protection that they deserve. But because of the Supreme Court's decision, we've seen a significant erosion in protections for older workers. And unfortunately, when older workers lose their jobs, they suffer irreversible financial damages, harming communities all across our nation. The Protecting Workers, Older Workers Against Discrimination Act will reinstall the legal standard necessary to protect those workers, and it will help keep our neighbors and their families whole. And that's really what we should want to do. In the 116th Congress, this body voted in a bipartisan manner to pass this critical legislation. Clearly, this is not about installing more regulations, as some of my colleagues have suggested. It's about doing a good and necessary work for the people. We should always want to do what's right because it's right. And let's make sure that we remember that we're supposed to be working who we're working for. We're working for the people. So I urge my colleagues to vote against these amendments, and I yield back the balance of my time. Thank you, Mr. Chairman.
Thank you. Are there other comments on the on this amendment? If not, the question is on the amendment offered by the gentlelady from Michigan, Ms. McLean. All in favor of the amendment will vote aye.
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 Opposed will vote no.
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 Noes appear to have it.
Mr. Chairman, I'm also amazed at the ability of people getting together as a bad thing. I always thought that was a good concept. So with that said, I would request a recorded vote on this.
A recorded vote is requested, and that will be.
Thank you.
Oh, are there other amendments?
Mr. Chairman, I have an amendment at the desk.
Gentlelady from New York has an amendment at the desk. Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 2062, offered by Ms. Stefanik of New York. The code is H2062_005.
The gentlelady's recognize.
Mr. Chairman,
Who's seeking recognition?
Joe Courtney.
Joe,
Yeah, I just reserve
Yes.
a point of order.
Okay, point of order is reserved. The gentlelady from New York is recognized for 5 minutes on her amendment.
Thank you, Chairman Scott. My amendment simply clarifies that a preponderance of the evidence is required to prove age discrimination and Americans with Disabilities Act claims in HR 2062. The exceedingly broad language in the bill could result in confusion for the courts, EEOC workers, and employers. The language could be construed to mean that a preponderance of evidence is not required to prove claims under HR 2062. And preponderance of evidence is the common traditional standard in civil cases. My amendment simply clears up the ambiguity in the bill by stating that a preponderance of evidence is the standard for proving claims under HR 2062, and I urge my colleagues to support it. I also want to take a few moments to add comments on the underlying bill. Protecting older Americans against any instances of age discrimination in the workforce is a shared goal among members of this committee, because we know that as older workers stay in the workforce longer than previous generations, the later years of a worker's career can become increasingly unstable. A 2018 study found that 56% of all older workers aged 50 and above are pushed out of long-time jobs before they chose to retire, and only 1 in 10 will ever earn as much again. This economic strain can be significant for both them as individuals and their families. but losing a career is bigger than just financial security. Separating adults from the dignity of work has a broader impact on the well-being of communities like mine, where I serve one of the largest constituencies of older Americans in the country. I support the overarching purpose of this bill, addressing the Supreme Court's decision and reaffirming that age discrimination cannot be a motivating factor in employment decisions. However, Ranking Member Fox and committee Republicans have raised important issues with elements of this legislation that reach far beyond overruling Gross and protecting seniors. My clarifying amendment would ensure the underlying legislation does not create confusion for workers and employers while still fixing Gross by allowing the use of circumstantial evidence. Additionally, this committee should work to curtail the ability of trial lawyers to game mixed motive retaliation claims for their own benefit, not the benefit of workers. And we must ensure the underlying legislation preserves the collaborative process between employees and employers that has long been a hallmark of the Americans with Disabilities Act and helped millions of Americans secure accommodations in the workplace. For these reasons, I oppose the current language without these common sense changes and urge this committee and the bill's proponents to address the remaining issues in the text so we can gain broad bipartisan support necessary to become law. I yield back.
Thank you, and I recognize myself in opposition to the amendment. I want to thank the gentlelady for her engagement in the issue, but the amendment seems to require a preponderance of evidence in regards to ADEA and ADA claims is somewhat confusing because a lot of us thought the preponderance of evidence standard is already required under the McDonnell-Douglas case, and therefore the amendment is not needed. So I'm unclear the full intention of the amendment, and that would require more research. Regrettably, since this amendment was not submitted on the roster so that it could have been considered overnight, but just submitted this morning, there's no time to give serious consideration to it before it's time to vote on it. So I would hope that we could withdraw the amendment so that we could really give it serious consideration. In the alternative, I would recommend a no vote on the amendment, but indicate that we would see exactly what the problem that we're trying to cure. So with that, I yield back. Are there others that wish to speak to the amendment? If not, the question is on the amendment offered by the gentlelady.
Mr. Chairman, I withdraw the point of order.
I'm sorry. Thank you.
Yep.
The point of order is withdrawn. The question now is on the amendment offered by the gentlelady from New York. All who favor the amendment will vote aye.
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 All opposed, vote no.
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 The noes appear to have it.
Mr. Chairman, I request recorded vote.
Recorded vote is requested. It's my understanding that's the last amendment offered for this bill. We are now in a situation where we are to go back to the original votes, but it's my understanding that there is another committee that has several of our members involved, the Natural Resources Committee, which is meeting now, and they are actually voting right now. My understanding is they'll be voting till about 3 o'clock. And so we will recess until 3 p.m. and reconvene and take the recorded vote on amendments and final passage of the legislation before us. Are there any questions? If not,
Mr. Chairman.
Mr. Wilson.
First of all, I want to thank you for how the meeting was conducted, and also want to commend you for recognition of Senator John Warner. He and I share the distinction of being graduates of Washington Lee University in your home state. So I appreciate that. I do have an issue. I have a funeral that I was going to go to at 3 o'clock. If we could do it 4. And that way we can make sure that the natural resources people show up.
Let me check with staff and see what the possibilities are.
Mr. Chairman,
Um,
I can't do it at 4.
all right.
Timothy.
This is a reason why we should be taking it as it goes. And I'd recommend natural resources deal with it the way we would deal with it, back and forth.
Mr. Chairman, if we were here in Washington, people could be moving between one room and another, which we're very used to doing. So that's another reason why having them remotely is such a problem. Yeah, I know that we had a problem with the parliamentarian saying we couldn't keep votes open or let people vote after the votes were called. But is there any reason why you couldn't allow the votes to start at 3 o'clock? There are going to be conflicts no matter what time you do it. Some of us are getting on planes. If you could just keep the votes open till they're closed, people could vote. But that's the reason we should be in DC, where people could be moving from one room to the other. It's a really horrible disadvantage to do it this way.
Mr. Chairman, may I be heard on that last point?
Who is gentlelady from Pennsylvania, Ms. Wow?
Yes, Mr. Chairman, thank you so much. I just want to comment on that last point by the ranking member. I don't disagree that soon it will be time to get back to Washington, but quite frankly, moving between hearings is considerably easier when we are doing it virtually than when we are running all over campus in Washington. So I just take issue with that statement. The other problem is that there's a pretty important member briefing at 3 o'clock on the situation in Israel, which is very important to those of us who are on House Foreign Affairs as well as others. But I just point that out. I'm not objecting to the timing if the chairman wants to start votes at 3. Just wanted you to be aware of that.
Well, we've got several members who are actually in the process of voting right now in another, at least 3 or 4 members on our side. I don't know how many on the other side. And we were trying to, we're trying to beat them to the punch, but they started voting before we did, and they're actually in the process right now of voting. So as soon as they conclude, let's.
Mr. Chairman. Mr. Chairman.
Okay, well, let's instead of 3 o'clock, let's do it at 2:30 and move as quickly as we can.
Yeah, I was gonna suggest 2:30, Mr. Chairman.
Okay, the committee is in recess until 2:30. And we'll convene quickly at 2:30 and get to voting and vote as quickly as we can. And hopefully we can finish in time for the 3 o'clock funeral.
Thank you.
Okay. Thank you. The committee stands in recess until 2:30. at the end. We'll now begin voting on postponed amendments offered to HR 3110, beginning with the amendment in nature of a substitute offered by the ranking member, Dr. Fox. All in favor of that amendment will respond to the roll call by voting aye. All opposed will vote no. The clerk will call the roll.
Chairman Scott,
No.
Chairman Scott votes no. Mr. Grijalva, Mr. Courtney,
No.
Mr. Courtney votes no. Mr. Sablon, Ms. Wilson,
Ms. Wilson votes no.
Ms. Wilson votes no. Ms. Bonamici,
Suzanne Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano,
Mr. Takano votes no.
Mr. Takano votes no. Ms. Adams,
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier, Mr. Norcross,
No.
Mr. Norcross votes no. Ms. Jayapal, Mr. Morelli,
Morelli is no.
Mr. Morelli votes no. Ms. Wild,
Wild is a no.
Ms. Wild votes no. Mrs. McBath,
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes,
Mrs. Hayes votes no.
Mrs. Hayes votes no. Mr. Levin,
Levin votes no.
Mr. Levin votes no. Ms. Omar,
Omar votes no.
Ms. Omar votes no. Ms. Stevens,
Stevens is a no.
Ms. Stevens votes no. Ms. Leger Fernandez, Mr. Jones,
Jones votes no.
Mr. Jones votes no. Ms. Manning,
No.
Ms. Manning votes no. Mr. Mervan,
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman,
Mr. Bowman votes no.
Mr. Bowman votes no. Mr. Pocan,
Pocan votes no.
Mr. Pocan votes no. Mr. Castro,
Castro votes no.
Mr. Castro votes no. Ms. Cheryl,
Cheryl votes no.
Ms. Cheryl votes no. Mr. Yarmouth,
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat,
Espaillat votes no.
Mr. Espaillat votes no. Mr. Mfume, Ranking Member Fox.
Fox votes aye.
Mrs. Fox votes aye.
How is Sablon recorded?
Mr. Sablon, you are not recorded.
Sablon votes no.
Mr. Sablon votes no. Mr. Wilson,
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson, Mr. Walberg,
Mr. votes aye.
I'm so sorry about that. Mr. Walberg, you voted aye? Is that correct?
Mr. Wahlberg votes aye.
Thank you. Mr. Walberg voted aye. Mr. Grothman,
Aye.
Mr. Grothman votes aye. Ms. Stefanik,
Stefanik, aye.
Ms. Stefanik votes aye. Mr. Allen?
Allen votes aye.
Mr. Allen votes aye. Mr. Banks?
Mr. Banks votes yes.
Mr. Banks votes aye. Mr. Comer?
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher?
Fulcher votes aye.
Mr. Fulcher votes aye. Mr. Keller?
Keller votes yes.
Mr. Keller votes aye. Mr. Murphy?
Murphy votes yes.
Mr. Murphy votes aye. Mrs. Miller Meeks?
Miller Meeks, aye.
Mrs. Miller Meeks votes aye. Mr. Owens? Mr. Good?
Good votes no.
Mr. Good votes no. Mrs. McLean?
McLean votes yes.
Mrs. McLean votes aye. Mrs. Harshbarger?
Hirschberger votes aye.
Mrs. Harshbarger votes aye. Mrs. Miller?
Miller votes no.
Mrs. Miller votes no. Mrs. Sparks? Mr. Fitzgerald? Mr. Cawthorn?
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele?
Steele votes aye.
Mrs. Steele votes aye. Mrs. Letlow?
Letlow votes aye.
Ms. Letlow votes aye.
Mr. Chairman,
Who's seeking recognition?
Jayapal.
How is Ms. Jayapal recorded?
Ms. Jayapal is not recorded.
Jayapal votes no.
Ms. Jayapal votes no.
Mr. Chairman, Mr. DeSaulnier, how am I recorded?
How is Mr. DeSaulnier recorded?
Mr. DeSaulnier is not recorded.
DeSaulnier votes no.
Mr. DeSaulnier votes no.
Mr. Chairman, Leger Fernandez, how am I recorded?
How is Ms. Leger Fernandez recorded?
Ms. Leger Fernandez is not recorded.
Leger Fernandez votes no.
Ms. Leger Fernandez votes no.
Is any? Would the clerk call the names of those who did not respond?
Yes, sir. Mr. Grijalva? Mr. Mfume? Mr. Thompson? Mr. Owens? Mrs. Sparks? Mr. Fitzgerald? Chairman Scott, that's everyone.
Thank you. The clerk will report.
Mr. Chairman, on this vote, we have, we have 17 ayes and 27 noes.
17 ayes, 27 noes,
Excuse me, 17 ayes and 29 noes. My
29
apologies.
noes. 29 noes. The amendment is not adopted. The next amendment is 11th Amendment. The clerk will call the roll.
Chairman Scott.
Chairman Scott votes aye.
Chairman Scott votes aye. Mr. Grijalva.
Aye.
I'm sorry, Mr. Grijalva, I didn't get to see your face.
Aye.
Is your camera on, sir? Ah, I see you now. Okay. Could you repeat one more time?
Yeah, the camera wasn't on. Aye.
Mr. Grijalva votes aye. Mr. Courtney?
Aye.
Mr. Courtney votes aye. Mr. Sablon?
Saban votes aye.
Mr. Sablon votes aye. Ms. Wilson?
Ms. Wilson votes aye.
Ms. Wilson votes aye. Ms. Bonamici?
Bonamici votes aye.
Ms. Bonamici votes aye. Mr. Takano?
Mr. Takano votes aye.
Mr. Takano votes aye. Ms. Adams?
Ms. Adams votes aye.
Ms. Adams votes aye. Mr. DeSaulnier?
DeSaulnier, aye.
Mr. DeSaulnier votes aye. Mr. Norcross?
Norcross votes aye.
Mr. Norcross votes aye. Ms. Jayapal?
Jayapal votes aye.
Ms. Jayapal votes aye. Mr. Morelli?
Morelli is aye.
Mr. Morelli votes aye. Ms. Wild?
Wild votes aye.
Ms. Wild votes aye. Mrs. McBath?
McBath votes aye.
Mrs. McBath votes aye. Mrs. Hayes?
Mrs. Hayes votes aye.
Mrs. Hayes votes aye. Mr. Levin?
Levin votes aye.
Mr. Levin votes aye. Ms. Omar?
Omar votes aye.
Ms. Omar votes aye. Ms. Stevens?
Stevens votes aye.
Ms. Stevens votes aye. Ms. Leger Fernandez?
Leger Fernandez votes aye.
Ms. Leger Fernandez votes aye. Mr. Jones?
Jones votes aye.
Mr. Jones votes aye. Ms. Manning? Mr. Mervan?
Mervan votes aye.
Mr. Mervan votes aye. Mr. Bowman?
Bowman votes aye.
Mr. Bowman votes aye. Mr. Pocan?
Pocan votes aye.
Mr. Pocan votes aye. Mr. Castro?
Castro votes aye.
Mr. Castro votes aye. Ms. Sherrill?
Cheryl votes aye.
Ms. Sherrill votes aye. Mr. Yarmouth?
Yarmouth votes aye.
Mr. Yarmouth, I'm sorry, I can't see you. There you are. Could you repeat one more time?
Yarmouth votes aye.
Mr. Yarmouth votes aye. Mr. Espaillat?
Mr. Espaillat is aye.
Mr. Espaillat votes aye. Mr. Mfume? Ranking Member Fox?
Fox votes aye.
Ranking Member Fox votes aye. Mr. Wilson?
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson? Mr. Wahlberg?
Mr. Wahlberg votes aye.
Mr. Wahlberg votes aye. Mr. Grossman?
Aye.
Mr. Grossman votes aye. Ms. Stefanik?
Aye.
Ms. Stefanik votes aye. Mr. Allen?
Allen votes aye.
Mr. Allen votes aye. Mr. Banks?
Banks votes yes.
Mr. Banks votes aye. Mr. Comer?
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher?
Fulcher's aye.
Mr. Fulcher votes aye. Mr. Keller?
Yes.
Mr. Keller votes aye. Mr. Murphy?
Murphy votes yes.
Mr. Murphy votes aye. Mrs. Miller Meeks,
Miller Meeks, aye.
Mrs. Miller Meeks votes aye. Mr. Owens, Mr. Good,
Good votes no.
Mr. Good votes no. Mrs. McLean,
McLean votes aye.
Mrs. McLean votes aye. Mrs. Harshbarger,
Hirschberger votes no.
Mrs. Harshbarger votes no. Mrs. Miller,
Miller votes no.
Mrs. Miller votes no. Mrs. Sparts, Mr. Fitzgerald, Mr. Cawthorn,
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele,
Steele votes aye.
Mrs. Steele votes aye. Ms. Letlow,
Letlow votes aye.
Ms. Letlow votes aye.
How is Mrs. Manning recorded?
Mrs. Manning is not recorded.
Does anyone else seek to be recorded? If not, the clerk will report. Did Ms. Manning seek to be recorded? You're on mute, Ms. Manning. Is Ms. Manning?
Thank you. I'm sorry. I was having trouble unmuting.
Okay.
This is a,
How is Ms. Manning recorded?
I'm
Ms.
sorry.
Manning is not recorded.
I'm sorry, Mr. Chairman, how did you vote on this?
Yes.
Thank you. This is Manning votes yes.
Ms. Manning votes aye.
Thank you. Does anyone else seek to be recorded? If not, the clerk will report.
Mr. Chairman, on this vote, we have 44 ayes and 3 noes.
44 ayes, 3 noes. The amendment is adopted. The next order of business is the vote on the amendment in nature of a substitute as amended. The all in favor of the amendment in nature of a substitute as amended will vote aye.
Aye.
Aye. All opposed will vote no. Ayes appear to have it. The ayes have it. The amendment in nature of a substitute is adopted. And now we'll recognize there appear to be no other members to speak to the bill. And now we'll entertain a motion to report the bill and recognize the gentleman from New York, distinguished Vice Chair of the committee, Mr. Bowman.
Mr. Chairman, I move the Committee on Education and Labor report the bill HR 3110 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
The question now occurs on reporting HR 3110 as amended to the House with a favorable recommendation. All in favor will say aye.
Aye.
Aye. All opposed will say no.
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 No. No. The
No.
ayes appear to have it.
No, no, no.
The ayes appear to have it.
I'll record it vote.
I'm sorry. I asked for a recorded vote, Mr. Chairman.
Recorded vote is requested. The clerk will call the roll.
Chairman Scott,
Chairman Scott votes aye.
Chairman Scott votes aye. Mr. Grijalva.
Aye.
Mr. Grijalva votes aye. Mr. Courtney.
Aye.
Mr. Courtney votes aye. Mr. Sablon.
LeBlanc votes aye.
Mr. Sablon votes aye. Ms. Wilson.
Ms. Wilson votes aye.
Ms. Wilson votes aye. Ms. Bonamici.
Ms. Bonamici votes aye.
Ms. Bonamici votes aye. Mr. Takano.
Mr. Takano votes aye.
Mr. Takano votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Mr. DeSaulnier.
DeSaulnier votes aye.
Mr. DeSaulnier votes aye. Mr. Norcross.
Norcross votes aye.
Mr. Norcross votes aye. Ms. Jayapal.
Aye. Jayapal votes aye.
Ms. Jayapal votes aye. Mr. Morelli.
Morelli is aye.
Mr. Morelli votes aye. Ms. Wild.
Wild votes aye.
Ms. Wild votes aye. Mrs. McBath.
McBath votes aye.
Mrs. McBath votes aye. Mrs. Hayes.
Mrs. Hayes votes aye.
Mrs. Hayes votes aye. Mr. Levin.
Levin votes aye.
Mr. Levin votes aye. Ms. Omar.
Omar votes aye.
Ms. Omar votes aye. Ms. Stevens.
Stevens votes aye.
Ms. Stevens votes aye. Ms. Leger Fernandez.
Leger Fernandez votes aye.
Ms. Leger Fernandez votes aye. Mr. Jones.
Jones votes aye.
Mr. Jones votes aye. Ms. Manning.
Manning votes aye.
Ms. Manning votes aye. Mr. Mervan.
Mervan votes aye.
Mr. Mervan votes aye. Mr. Bowman.
Bowman votes aye.
Mr. Bowman votes aye. Mr. Pocan.
Pocan votes aye.
Mr. Pocan votes aye. Mr. Castro.
Castro votes aye.
Mr. Castro votes aye. Ms. Cheryl.
Cheryl votes aye.
Ms. Cheryl votes aye. Mr. Yarmouth.
Yarmouth votes aye.
Mr. Yarmouth votes aye. Mr. Espaillat.
Espaillat votes aye.
Mr. Espaillat votes aye. Mr. Mfume. Ranking Member Fox.
Fox votes no.
Mrs. Fox votes no. Mr. Wilson.
Mr. Wilson votes no.
Mr. Wilson votes no. Mr. Thompson. Mr. Wahlberg.
Wahlberg votes no.
Mr. Wahlberg votes no. Mr. Grossman.
No.
Mr. Grossman votes no. Ms. Stefanik.
Stefanik votes no.
Ms. Stefanik votes no. Mr. Allen.
Allen's no.
Mr. Allen votes no. Mr. Banks.
Banks votes no.
Mr. Banks votes no. Mr. Comer.
Comer votes no.
Mr. Comer votes no. Mr. Fulcher.
Fulcher votes no.
Mr. Fulcher votes no. Mr. Keller.
Keller votes no.
Mr. Keller votes no. Mr. Murphy.
Murphy votes no.
Mr. Murphy votes no. Mrs. Miller Meeks.
Miller Meeks no.
Mrs. Miller Meeks votes no. Mr. Owens. Mr. Good.
Good votes no.
Mr. Good votes no. Mrs. McLean.
Mrs. McLean votes no.
Mrs. McLean votes no. Mrs. Harshbarger.
Hirschberger votes no.
Mrs. Harshbarger votes no. Mrs. Miller.
Miller votes no.
Mrs. Miller votes no. Mrs. Sparks. Mr. Fitzgerald. Mr. Cawthorn.
Cawthorn votes no.
Mr. Cawthorn votes no. Mrs. Steele.
Steele votes no.
Mrs. Steele votes no. Ms. Letlow.
Letlow votes no.
Ms. Letlow votes no.
Is anyone not recorded? Clerk will report.
Chairman Scott, on this vote, there are 28 ayes and 19 noes.
28 ayes, 19 noes. The ayes have it and the motion is agreed to. HR 3110 is ordered reported to the U.S. House of Representatives. Chair notes for the record that a quorum is present. As unanimous consent that the staff is authorized to make necessary and technical and conforming changes to the bill as amended. Pursuant to House Rule 11, Clause 2L, I give notice that all members have the requisite number of days to file supplemental, minority, additional, or dissenting views. Without objection, so ordered. We will now begin voting on postponed amendments offered to HR 2062. The first vote will be on the Fox Amendment, which strikes the provision providing a mixed motive evidentiary standard under Title VII. Clerk will call the roll. Is the clerk with us? I'm sorry.
Apologies, my papers fell apart.
Oh, I'm sorry. Okay.
Chairman Scott.
Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva,
Oh.
could you repeat, Mr. Grijalva?
No.
Mr. Grijalva votes no. Mr. Courtney?
No.
Mr. Courtney votes no. Mr. Sablon?
Sablon votes no.
Mr. Sablon votes no. Ms. Wilson?
Wilson votes no.
Ms. Wilson votes no. Ms. Bonamici?
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano?
Takano votes no.
Mr. Takano votes no. Ms. Adams?
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier?
DeSaulnier, no.
Mr. DeSaulnier votes no. Mr. Norcross?
Norcross votes no.
Mr. Norcross votes no. Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli?
Morelli is no.
Mr. Morelli votes no. Ms. Wild?
Wild votes no.
Ms. Wild votes no. Mrs. McBath?
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes?
Mrs. Hayes votes no.
Mrs. Hayes votes no. Mr. Levin?
Levin.
Ms. Omar?
No, sorry.
Sorry, Mr. Levin votes no. Ms. Omar?
Omar votes no.
Ms. Omar votes no. Ms. Stevens?
Stevens votes no.
Ms. Stevens votes no. Ms. Leger Fernandez?
Leger Fernandez votes no.
Ms. Leger Fernandez votes no. Mr. Jones?
Jones votes no.
Mr. Jones votes no. Ms. Manning?
Manning votes no.
Ms. Manning votes no. Mr. Mervan?
Mr. Mervan votes no.
Mr. Mervan votes no. Mr. Bowman?
Bowman votes no.
Mr. Bowman votes no. Mr. Pocan?
Pocan votes no.
Mr. Pocan votes no. Mr. Castro?
Castro votes no.
Mr. Castro votes no. Ms. Sherrill?
Cheryl votes no.
Ms. Sherrill votes no. Mr. Yarmouth?
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat?
Espaillat votes no.
Mr. Espaillat votes no. Mr. Mfume? Ranking Member Fox?
Sorry, Fox votes aye.
Mrs. Fox votes aye. Mr. Wilson?
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson? Mr. Wahlberg?
Wahlberg, aye.
Mr. Wahlberg votes aye. Mr. Grossman?
Aye.
Mr. Grossman votes aye. Ms. Stefanik?
Stefanik, aye.
Ms. Stefanik votes aye. Mr. Allen?
Allen, aye.
Mr. Allen votes aye. Mr. Banks?
Banks votes yes.
Mr. Banks votes aye. Mr. Comer?
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher?
Fulcher votes aye.
Mr. Fulcher votes aye. Mr. Keller?
Yes.
Mr. Keller votes aye. Mr. Murphy?
Murphy is a yes.
Mr. Murphy votes aye. Mrs. Miller Meeks?
Miller Meeks, aye.
Mrs. Miller Meeks votes aye. Mr. Owens? Mr. Good?
Good votes yes.
Mr. Good votes aye. Mrs. McLean?
McLean votes yes.
Mrs. McLean votes aye. Mrs. Harshbarger?
Hirschberger votes aye.
Mrs. Harshbarger votes aye. Mrs. Miller?
Miller votes yes.
Mrs. Miller votes aye. Mrs. Sparks? Mr. Fitzgerald? Mr. Cawthorn?
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele?
Steele votes aye.
Mrs. Steele votes aye. Ms. Letlow?
Letlow votes aye.
Ms. Letlow votes aye.
Are there any members who were not recorded? If not, the clerk will report.
Chairman Scott, on this vote, we have 19 ayes and 28 nays.
19 ayes, 28 nays. The amendment is not adopted. The next amendment is the Allen Amendment on the GAO study. Clerk will call the roll.
Chairman Scott.
Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva?
Grijalva votes no.
Mr. Grijalva votes no. Mr. Courtney?
Courtney votes no.
Mr. Courtney votes no. Mr. Sablon?
Sablon votes no.
Mr. Sablon votes no. Ms. Wilson?
Wilson votes no.
Ms. Wilson votes no. Ms. Bonamici?
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano?
Takano votes no.
Mr. Takano votes no. Ms. Adams?
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier?
DeSaulnier no.
Mr. DeSaulnier votes no. Mr. Norcross?
Norcross votes no.
Mr. Norcross votes no. Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli?
Morelli is no.
Mr. Morelli votes no. Ms. Wild?
Wild votes no.
Ms. Wild votes no. Mrs. McBath?
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes? Mr. Levin?
Levin votes no.
Mr. Levin votes no. Ms. Omar?
Omar votes no.
Ms. Omar votes no. Ms. Stevens?
Stevens is a no. Votes no.
Ms. Stevens votes no. Ms. Leger Fernandez?
No.
Ms. Leger Fernandez votes no. Mr. Jones?
Votes no.
Mr. Jones votes no. Ms. Manning?
Manning votes no.
Ms. Manning votes no. Mr. Mervan?
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman?
Mr. Bowman votes no.
Mr. Bowman votes no. Mr. Pocan?
Pocan votes no.
Pocan votes no. Mr. Castro?
Castro votes no.
Mr. Castro votes no. Ms. Cheryl?
Cheryl votes no.
Ms. Cheryl votes no. Mr. Yarmouth?
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat?
Espaillat votes no.
Mr. Espaillat votes no. Mr. Mfume? Ranking Member Fox?
Fox votes aye.
Mrs. Fox votes aye. Mr. Wilson?
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson? Mr. Wahlberg.
Wahlberg votes aye.
Mr. Wahlberg votes aye. Mr. Grossman.
Aye.
Mr. Grossman votes aye. Ms. Stefanik.
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen.
Allen's aye.
Mr. Allen votes aye. Mr. Banks.
Banks votes yes.
Mr. Banks votes aye. Mr. Comer.
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher.
Fulcher votes aye.
Mr. Fulcher votes aye. Mr. Keller.
Yes.
Mr. Keller votes aye. Mr. Murphy.
Murphy is a yes.
Mr. Murphy votes aye. Mrs. Miller Meeks.
Miller Meeks, aye.
Mrs. Miller Meeks votes aye. Mr. Owens. Mr. Good.
Good votes yes.
Mr. Good votes aye. Mrs. McLean.
McLean votes aye.
Mrs. McLean votes aye. Mrs. Harshbarger.
Harshbarger votes aye.
Mrs. Harshbarger votes aye. Mrs. Miller. Mrs. Sparts. Mr. Fitzgerald. Mr. Cawthorn.
Hawthorne votes aye.
Mr. Cawthorn votes aye. Mrs. Steele.
Steele votes aye.
Mrs. Steele votes aye. Ms. Letlow.
Letlow votes aye.
Ms. Letlow votes aye.
I have to get on that.
How is the gentlelady from Connecticut, Ms. Hayes, recorded?
Ms. Hayes is not recorded.
May I vote? Mary Miller?
How is Mrs. Miller recorded?
Ms. Miller is not recorded.
Ms. Miller, how do you want to vote?
I'm an aye.
Mrs. Miller votes aye.
Clerk will report.
Chairman Scott, on this vote, we have 19 ayes and 27 noes.
19 ayes and 27 noes. The amendment is not adopted. The next amendment is the amendment offered by the gentleman from Virginia, Mr. Good, adding a finding. Clerk will call the roll.
Chairman Scott.
Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva.
Grijalva votes no.
Mr. Grijalva votes no. Mr. Courtney.
Courtney votes no.
Mr. Courtney votes no. Mr. Sablan.
Was Sablan called? I'm sorry. Was Sablan called?
Yes, Mr. Sablan.
No.
Mr. Sablan votes no. Ms. Wilson.
Ms. Wilson votes no.
Ms. Wilson votes no. Ms. Bonamici.
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano.
Takano votes no.
Mr. Takano votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier.
DeSaulnier votes no.
Mr. DeSaulnier votes no. Mr. Norcross.
Norcross votes no.
Mr. Norcross votes no. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli.
Morelli is no.
Mr. Morelli votes no. Ms. Wild.
Wild is a no.
Ms. Wild votes no. Mrs. McBath.
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes.
Mrs. Hayes votes no.
Mrs. Hayes votes no. Mr. Levin.
Levin votes no.
Mr. Levin votes no. Ms. Omar.
Omar votes no.
Ms. Omar votes no. Ms. Stevens.
Stevens votes no.
Ms. Stevens votes no. Ms. Leger Fernandez.
No.
Ms. Leger Fernandez votes no. Mr. Jones?
Jones votes no.
Mr. Jones votes no. Ms. Manning?
Manning votes no.
Ms. Manning votes no. Mr. Mervan?
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman?
Bowman votes no.
Mr. Bowman votes no. Mr. Pocan?
Can votes no.
Mr. Pocan votes no. Mr. Castro?
Castro votes no.
Mr. Castro votes no. Ms. Cheryl?
Cheryl votes no.
Ms. Cheryl votes no. Mr. Yarmouth?
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat?
Espaillat votes no.
Mr. Espaillat votes no. Mr. Mfume? Ranking Member Fox?
Fox votes aye, sorry.
Okay, could you repeat? I can see you now.
Fox votes aye.
Mrs. Fox votes aye. Mr. Wilson?
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson? Mr. Wahlberg?
Wahlberg votes aye.
Mr. Wahlberg votes aye. Mr. Grossman?
Aye.
Mr. Grossman votes aye. Ms. Stefanik?
Stefanik, aye.
Ms. Stefanik, can you repeat?
Stefanik, aye.
Ms. Stefanik votes aye. Mr. Allen? Mr. Banks?
Did you get mine? Alan is aye.
Mr. Allen is aye. Mr. Banks?
Banks votes yes.
Mr. Banks, aye. Mr. Comer?
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher?
Fulcher votes aye.
Mr. Fulcher votes aye. Mr. Keller?
Yes.
Mr. Keller votes aye. Mr. Murphy?
Murphy, yes.
Mr. Murphy votes aye. Mrs. Miller Meeks?
Yes.
Mrs. Miller Meeks votes aye. Mr. Owens? Mr. Good?
Good votes yes.
Mr. Good votes aye. Mrs. McLean?
McLean votes aye.
Mrs. McLean votes aye. Mrs. Harshbarger?
Hirschberger votes aye.
Mrs. Harshbarger votes aye. Mrs. Miller?
Miller votes.
Mrs. Miller, could you repeat?
Miller votes aye.
Mrs. Miller votes aye. Mrs. Sparts? Mr. Fitzgerald? Mr. Cawthorn?
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele?
Steele votes aye.
Mrs. Steele votes aye. Ms. Letlow?
Letlow votes aye.
Ms. Letlow votes aye.
Anyone not recorded? Clerk will report.
Chairman Scott, on this vote, we have 19 ayes and 28 noes.
19 ayes, 28 noes. The amendment is not agreed to. The next amendment is offered by the gentlelady from Michigan, Ms. McLean, which speaks to whether or not a plaintiff may rely solely on the fact that an employer is engaged in an interactive process with an employee or job applicant to determine a reasonable accommodation in order to establish a discriminatory practice. Clerk will call the roll.
Chairman Scott?
No. Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva?
Grijalva votes no.
Mr. Grijalva votes no. Mr. Courtney?
Courtney votes no.
Mr. Courtney votes no. Mr. Sablon?
Sablon votes no.
Mr. Sablon votes no. Ms. Wilson?
Ms. Wilson votes no.
Ms. Wilson votes no. Ms. Bonamici?
Bonamici votes no.
Ms. Bonamici votes no. Mr. Decano?
Decano votes no.
Mr. Decano votes no. Ms. Adams?
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier?
DeSaulnier votes no.
Mr. DeSaulnier votes no. Mr. Norcross?
Norcross votes no.
Mr. Norcross votes no. Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli?
Morelli votes no.
Mr. Morelli votes no. Ms. Wild?
Wild votes no.
Ms. Wild votes no. Mrs. McBath?
Bath votes no.
Mrs. McBath votes no. Mrs. Hayes?
Mrs. Hayes votes no.
Mrs. Hayes votes no. Mr. Levin?
Levin votes no.
Mr. Levin votes no. Ms. Omar?
Omar votes no.
Ms. Omar votes no. Ms. Stevens?
The gentlelady from Michigan votes no.
Ms. Stevens votes no. Ms. Leger Fernandez?
The gentlewoman from New Mexico votes no.
Ms. Leger Fernandez votes no. Mr. Jones?
Gentleman from New York votes no.
Mr. Jones votes no. Ms. Manning?
Gentlewoman from North Carolina votes no.
Ms. Manning votes no. Mr. Mervan?
Frank Mervan from Indiana votes no.
Mr. Mervan votes no. Mr. Bowman?
Bowman votes no.
Mr. Bowman votes no. Mr. Pocan?
And votes no.
Mr. Pocan votes no. Mr. Castro?
But Castro votes no.
Mr. Castro votes no. Ms. Cheryl?
Cheryl votes no.
Ms. Cheryl votes no. Mr. Yarmouth?
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat?
The Latin from Manhattan, Espaillat votes no.
Mr. Espaillat votes no. Mr. Nkume? Ranking Member Fox?
Ms. Fox votes aye.
Mrs. Fox votes aye. Mr. Wilson?
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson? Mr. Wahlberg?
Wahlberg votes aye.
Mr. Wahlberg votes aye. Mr. Grossman?
Aye.
Mr. Grossman votes aye. Ms. Stefanik?
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen?
Allen is aye.
Mr. Allen votes aye. Mr. Banks?
Banks votes yes.
Mr. Banks votes aye. Mr. Comer? Mr. Fulcher?
Fulcher votes aye.
Mr. Fulcher votes aye. Mr. Keller?
Yes.
Mr. Keller votes aye. Mr. Murphy?
Murphy votes aye.
Mr. Murphy votes aye. Mrs. Miller Meeks?
Aye.
Mrs. Miller Meeks votes aye. Mr. Owens? Mr. Good?
Good votes yes.
Mr. Good votes aye. Mrs. McLean?
McLean votes aye.
Mrs. McLean votes aye. Mrs. Harshbarger?
Harshberger votes aye.
Mrs. Harshbarger votes aye. Mrs. Miller?
Miller votes aye.
Mrs. Miller votes aye. Mrs. Sparts? Mr. Fitzgerald? Mr. Cawthorn?
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele?
Steele votes aye.
Mrs. Steele votes aye. Ms. Letlow?
Letlow votes aye.
Ms. Letlow votes aye.
Mr. Chairman, how is Comer recorded?
How is Mr. Comer reported?
Mr. Comer is not recorded.
You skipped me. I vote yes.
Mr. Comer votes yes.
I think she called you, you didn't respond. So there must have been some miscommunication. Anyone else not recorded? Clerk will report.
Chairman Scott, on this vote, we have 19 ayes and 28 noes.
19 ayes, 28 noes. The amendment is not agreed to. The final amendment to the amendment in nature of a substitute is the amendment offered by the gentlelady from New York, Ms. Stefanik, on the preponderance of the evidence. Clerk will call the roll.
Chairman Scott.
Chairman Scott votes no.
Chairman Scott votes no. Mr. Grijalva.
Grijalva votes no.
Mr. Grijalva votes no. Mr. Courtney.
Courtney votes no.
Mr. Courtney votes no. Mr. Sablon.
Sablon votes no.
Mr. Sablon votes no. Ms. Wilson.
Mrs. Wilson votes no.
Ms. Wilson votes no. Ms. Bonamici.
Bonamici votes no.
Ms. Bonamici votes no. Mr. Takano.
Takano votes no.
Mr. Takano votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Mr. DeSaulnier.
DeSaulnier votes no.
Mr. DeSaulnier votes no. Mr. Norcross.
Norcross votes no.
Mr. Norcross votes no. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Mr. Morelli.
Morelli votes no.
Mr. Morelli votes no. Ms. Wild.
Wild votes no.
Ms. Wild votes no. Mrs. McBath.
McBath votes no.
Mrs. McBath votes no. Mrs. Hayes.
Mrs. Hayes votes no.
Mrs. Hayes votes no. Mr. Levin.
Stevens is a no.
Ms. Omar.
Omar is a no.
Ms. Omar votes no. Ms. Stevens.
Sorry, Stevens is a no. I'm not trying to vote for the gentleman from Michigan. I'm
Ms.
apologies.
Stevens votes no. Ms. Leger Fernandez.
Leger Fernandez votes no.
Ms. Leger Fernandez votes no. Mr. Jones.
Jones votes no.
Mr. Jones votes no. Ms. Manning.
Manning votes no.
Ms. Manning votes no. Mr. Mervan.
Mervan votes no.
Mr. Mervan votes no. Mr. Bowman.
Bowman votes no.
Mr. Bowman votes no. Mr. Buchan.
Buchan votes no.
Buchan votes no. Mr. Castro.
Castro votes no.
Mr. Castro votes no. Ms. Cheryl.
Cheryl votes no.
Ms. Cheryl votes no. Mr. Yarmouth.
Yarmouth votes no.
Mr. Yarmouth votes no. Mr. Espaillat.
Espaillat votes no.
Mr. Espaillat votes no. Mr. Mfume. Ranking Member Fox.
Fox votes aye.
Ranking Member Fox votes aye. Mr. Wilson.
Mr. Wilson votes aye.
Mr. Wilson votes aye. Mr. Thompson. Mr. Wahlberg.
Wahlberg votes aye.
Mr. Wahlberg votes aye. Mr. Grothman.
Aye.
Mr. Grothman votes aye. Ms. Stefanik.
Stefanik votes aye.
Ms. Stefanik votes aye. Mr. Allen.
Aye.
Mr. Allen votes aye. Mr. Banks.
Banks votes yes.
Mr. Banks votes aye. Mr. Comer.
Comer votes yes.
Mr. Comer votes aye. Mr. Fulcher.
Fulcher votes aye.
Mr. Fulcher votes aye. Mr. Keller.
Yes.
Mr. Keller votes aye. Mr. Murphy.
Murphy votes yes.
Mr. Murphy votes aye. Mrs. Miller Meeks.
Miller Meeks, aye.
Mrs. Miller Meeks votes aye. Mr. Owens. Mr. Good.
Votes yes.
Mr. Good votes aye. Mrs. McLean.
McLean votes aye.
Mrs. McLean votes aye. Mrs. Harshbarger.
Hirschberger votes aye.
Mrs. Harshbarger votes aye. Mrs. Miller.
Miller votes aye.
Mrs. Miller votes aye. Mrs. Sparks. Mr. Fitzgerald. Mr. Cawthorn.
Cawthorn votes aye.
Mr. Cawthorn votes aye. Mrs. Steele.
Steele votes aye.
Mrs. Steele votes aye. Ms. Letlow.
Letlow votes aye.
Ms. Letlow votes aye.
Anyone not recorded?
Mr. Chairman, how am I recorded? It's 11.
How's Mr. Levin recorded?
Mr. Levin is not recorded.
Mr. Chairman, I vote no.
Mr. Levin votes no.
Is anyone else not recorded? Clerk will report.
It's a real honor to be standing to
Chairman
speak.
Scott, on this vote, we have 19 yeas and 28 noes.
19 ayes, 28 noes. The amendment is not adopted. The question now occurs on the amendment in the nature of a substitute. All in favor, say aye. Aye. All opposed, say no. No, the ayes appear to have it. The ayes have it, and the amendment in nature of a substitute is agreed to. There being no other members who appear to speak on the bill, there appear to be no other members to speak on the bill. I now entertain a motion to report the bill and recognize the gentleman from New York, the distinguished vice chair of the committee, Mr. Bowman.
Thank you, Mr. Chairman. Mr. Chairman, I move the Committee on Education and Labor report the bill HR 2062 to the House of Representatives with an amendment in the nature of a substitute and with the recommendation that the amendment be agreed to and the bill as amended do pass.
Question now occurs on reporting HR 2062 as amended to the House with a favorable recommendation. All in favor, say aye. Aye.
Aye.
Aye.
Aye.
Aye.
All opposed, say no.
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 In the opinion of the chair, the ayes have it.
Mr. Chairman, on that, I request a recorded vote.
A recorded vote has been requested, and the clerk will call the roll.
Chairman Scott.
Chairman Scott votes aye.
Chairman Scott votes aye. Mr. Grijalva.
Grijalva votes aye.
Mr. Grijalva votes aye. Mr. Courtney.
Courtney votes aye.
Mr. Courtney votes aye. Mr. Sablon.
Sablon votes aye.
Mr. Sablon votes aye. Ms. Wilson. Ms. Bonamici.
Bonamici votes aye.
Ms. Bonamici votes aye. Mr. Takano.
Takano votes aye.
Mr. Takano votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Mr. DeSaulnier.
DeSaulnier votes aye.
Mr. DeSaulnier votes aye. Mr. Norcross.
Norcross votes aye.
Mr. Norcross votes aye. Ms. Jayapal.
Jayapal votes aye.
Ms. Jayapal votes aye. Mr. Morelli.
Morelli is aye.
Mr. Morelli votes aye. Ms. Wild.
Wild votes aye.
Ms. Wild votes aye. Mrs. McBath.
McBath votes aye.
Mrs. McBath votes aye. Mrs. Hayes.
Mrs. Hayes votes aye.
Mrs. Hayes votes aye. Mr. Levin.
Levin votes aye.
Mr. Levin votes aye. Ms. Omar.
Omar votes aye.
Ms. Omar votes aye. Ms. Stevens.
Stevens votes aye.
Ms. Stevens votes aye. Ms. Leger Fernandez.
Leger Fernandez votes aye.
Ms. Leger Fernandez votes aye. Mr. Jones.
Votes aye.
Mr. Jones votes aye. Ms. Manning.
Manning votes aye.
Ms. Manning votes aye. Mr. Mervan.
Mervan votes aye.
Mr. Mervan votes aye. Mr. Bowman.
Mr. Bowman votes aye.
Mr. Bowman votes aye. Mr. Pocan.
Pocan votes aye.
Mr. Pocan votes aye. Mr. Castro.
Castro votes aye.
Mr. Castro votes aye. Ms. Sherrill.
Cheryl votes aye.
Ms. Sherrill votes aye. Mr. Yarmouth.
Yarmouth votes aye.
Mr. Yarmouth votes aye. Mr. Espaillat.
Espaillat votes aye.
Mr. Espaillat votes aye. Mr. Mfume. Ranking Member Fox.
Fox votes no.
Mrs. Fox votes no. Mr. Wilson.
Mr. Wilson votes no.
Mr. Wilson votes no. Mr. Thompson. Mr. Wahlberg.
Wahlberg votes no.
Mr. Wahlberg votes no. Mr. Grothman.
Aye.
Mr. Grothman votes aye. Ms. Stefanik.
Stefanik votes no.
Ms. Stefanik votes no. Mr. Allen.
Mr. Allen votes no.
Mr. Allen votes no. Mr. Banks?
Banks votes no.
Mr. Banks votes no. Mr. Comer?
Comer votes no.
Mr. Comer votes no. Mr. Fulcher?
Fulcher votes no.
Mr. Fulcher votes no. Mr. Keller?
No.
Mr. Keller votes no. Mr. Murphy?
Murphy is a no.
Mr. Murphy votes no. Mrs. Miller Meeks?
Miller Meeks, no.
Mrs. Miller Meeks votes no. Mr. Owens? Mr. Good?
Good votes no.
Mr. Good votes no. Mrs. McLean?
McLean votes no.
Mrs. McLean votes no. Mrs. Harshbarger?
Hirschberger votes no.
Mrs. Harshbarger votes no. Mrs. Miller?
Miller votes no.
Mrs. Miller votes no. Mrs. Sparks? Mr. Fitzgerald? Mr. Cawthorn?
Cawthorn votes no.
Mr. Cawthorn votes no. Mrs. Steele?
Steele votes no.
Ms. Steele votes no. Ms. Letlow?
Letlow votes no.
Ms. Letlow votes no.
How is the gentlelady from Florida, Ms. Wilson, recorded?
Ms. Wilson is not recorded.
Ms. Wilson votes yes.
Mrs. Wilson votes yes.
Is anyone else not recorded? Clerk will report.
Mr. Chairman, while you're waiting, I'd just like to say thank you to you for working hard to accommodate everybody being able to vote this afternoon. It was difficult, I know, juggling all the schedules, but I appreciate that. Thank you.
Well, thank you. We did the best we could. Thank you.
Yes, sir.
Chairman Scott, on this vote, we have 29 ayes and 18 noes.
Thank you. The 28 ayes, 18 noes, the ayes have it, and the
Excuse
motion
me,
is.
Mr. Chairman, it's 29 ayes and 18 noes.
Thank you. 29 ayes and 18 noes. The ayes have it, and the motion is agreed to. HR 2062 is ordered, reported to the House of Representatives. The chair notes for the record that a quorum is present. So I ask unanimous consent that the staff is authorized to make necessary and technical and conforming changes to the bill as amended pursuant to House Rule 11, Clause 2L. I give notice to all members that they have the requisite number of days to file supplemental, minority, additional, or dissenting views. That objection, so ordered. That objection, any members who wish to insert materials into the record may do so by submitting them to the committee clerk electronically by the end of the day today. If there's no further business to come before the committee, and I want to thank everyone for their indulgence and cooperation. Without objection, the committee now stands adjourned. Thank you.